wonder what that was. Was weird. Good morning.
Good morning.
Morning.
The pretty picture said Anna Kippenbrock.
Nice, Anna. You've turned into a picture.
Anna's so pretty, she doesn't need to have a picture. Some of us should consider whether we should change rule 1.2.2 to allow us to have pictures instead of ourselves, our aging selves.
Thank you, Miss Anna. Are we live streaming?
Yes.
Okay.
So I'm leaving now.
Okay. Thank you. Okay, are we going to have any procedural issues that we need to deal with before we resume our evidentiary portion of the... Doesn't look like we are.
Madam Examiner,
Hello there.
how are you?
I'm doing okay. How are
Good.
you?
Excellent.
I don't see you, but I hear you.
Hold on. There I am.
Oh, there you are.
I am entering my appearance for the county today.
Okay.
I'm in place of Keith, who is out for the day.
Okay. Very well, Miss Winter. Thank you.
Thank you.
All right. Well, if we're not going to have any procedural issues that we need to deal with, hopefully we are going to conclude our evidentiary portion today. I do want to let the parties know that in an effort to have exhibits that conform with my rulings, and also that at least don't say they're confidential in the heading, I did put MLS 23 and 26. And 23 is the bid information. Is that right?
That's correct.
And the Wien bid information, and then 26 is the Rio Grande 8 manual, and both of those are now in the regular Dropbox, and they are designated as 23 and 26, and it doesn't say anything about confidential. Now, the documents, at least the bid information, that says confidential in the Excel spreadsheet, and I can't change that. So I was afraid I might do something to one of the cells. So I just want parties to know that's my understanding. The two documents are not confidential anymore. If that's wrong, let me know immediately, because they're in the regular Dropbox. So that's the only thing I wanted to let Miss Souls.
Yes, ma'am. There is a corrected exhibit MLS-23 that strikes through the confidential designation and changes the pink page to not pink per your instructions earlier this week.
Okay.
I am able to do the same thing and create a corrected MLS-26 if that's your pleasure.
You know, I think I just want to leave them the way they are, as long as they're not confidential and everybody agrees that this is the non-confidential exhibit that should be admitted.
Then when I go to ask to admit my testimony, which would include those exhibits, I should ask to admit exhibit MLS-23 as it stands, not the corrected version. Is that correct?
I think what I labeled your 23 as MLS Exhibit 23 DAC 02-04 Attachment 1. And then it has the bid information. And then I just went out of
So Madam Hearing Examiner.
hey, I'm not finished. Okay, and then I labeled MLS Exhibit 26, and I have a RG8 overhaul MLS 03-01 attachment.
I'll need to go to the Dropbox again.
Here,
Thank you.
I'll just share it. Hang on. Wrong screen. All right, share it. Screen 2.
That's not it. Oh.
Okay,
Yes, ma'am.
so that's your MLS 26, right?
Yes, it is.
Okay. And everybody agrees that it's not confidential, even though it says confidential on the top.
And Madam Hearing Examiner, which I was going to ask is, so what you're saying is we should be, or Ms. Souls and all of us should be using the MLS Exhibit 23 that now, when I'm in the Dropbox, says it was 37 minutes ago.
Yep.
And the MLS 26, 28 minutes ago.
Those
are the ones, right?
That's not really the point, Miss Stevens. You can use whatever version of this you want to use. I'm just trying to make it easier for the parties to understand exactly which exhibit is going to go with the transcript and is officially part of it, because I don't want 3 years from now somebody to have to come in and correct my transcript like I had to correct the 21-00064 transcript, because that was a nightmare. Okay, so I want us to have a correct version of every exhibit that we're actually entering. And even before that, I want to make sure that I don't have a confidential exhibit in the public, because that's inappropriate and I really don't want to get sued. Okay. So, because I think all my money is going to go to the vet.
Oh, how's she doing?
She's still alive. So it's another good day. Ms. Olson's prediction of
the antidote worked.
Of the probably the care, the drugs, and probably because she's
one tough puppy,
old and tough. That's right. Those bagels. What can I say? So thank you for asking. So that's just my point, Ms. Stevens. You can use whatever version as long as we're in agreement that they're not confidential.
Well, yeah.
Okay.
Thank you.
Ms. Souls, did that answer your question?
Yes, ma'am. Thank you.
Thank you. I heard you. I heard Miss Olson. Hello there, Mr. Lee.
Good morning, Judge.
Nice tie.
Thank you.
What are you thinking there, Miss Olson?
Oh, I'm still having trouble with Dropbox because I look at the link that Anna sent on Monday and nothing has been updated in there. And then I look at the link that you sent yesterday and I'm still not seeing the MLS 23 that you sent in. So I'm wondering if there could be something wrong with my Dropbox. And I apologize that I haven't had a chance to work with our paralegal because by the time we finished yesterday, she was gone. And then this morning, I was getting ready for the hearing and didn't have a chance to touch base with her. So I don't want to be difficult or cause problems, but I just am not prepared to comment on the actual documents themselves because I still haven't seen them. As far as confidentiality goes, if we're still talking about the documents that Ms. Sewell's attached with her testimony as reflected in our response brief on the confidentiality thing. We didn't have any concerns with anything other than the costing models, which I understand you've ruled are confidential. And so as far as you're concerned about putting something in there that's confidential, as long as it's not the costing model documents, I think we're fine. But I don't know why I can't find the documents in Dropbox.
Okay.
May I make a suggestion, Madam Hair Examiner? Because I just did this a second ago using Anna's link from several days ago. Carrie, did you
There's
try?
two links.
Oh.
Let me just say that.
Oh,
You understand there's two links, right? There's the regular Dropbox link that Anna sent earlier in the week. And then there's the confidential Dropbox link that I sent yesterday. Okay.
Yeah.
So the two documents that I put in this morning are in the regular Dropbox link.
which is the one
Yeah.
Anna sent.
And if you sort by,
Friday.
if you sort by modified, it seems like
That
you
was-
can find them.
That was what I was going to suggest. If you sort by modified, they should be at the very bottom because they're the
Yep.
most recent.
Oh, okay. Now I am finding it. Thank you.
Because if you try
Okay.
to go by name, you'll go crazy.
Um,
There's so many.
and we'll once we go on the record here in a couple of minutes, we'll have Miss Souls. You can ask her, or I'll ask her that, Miss Olson, just to make sure that the documents. I pulled the confidential documents from her email when she served the testimony at the beginning of May. Okay. So if you all have looked at those, and we'll verify no changes were made. The only change I made to Ms. Soul's exhibit was the name. Okay. I just removed the confidential name, because originally it says confidential materials on it. Okay.
Okay, and I apologize if I'm being done. But so I understand now we've got 23 and 26 addressed, but it seemed like the MLS workbooks, whatever those were, there's like a number of other documents that suffer from the same problem. And as I say, I'm not terribly concerned about.
Confidential or not confidential?
Well, I think they're still in that bucket of documents that EPE had initially claimed confidential, but in an effort to try to produce as much public as possible, they agreed that they wouldn't assert confidentiality for them.
Mhm.
So again, not the costing models, but things that are within that MLS exhibits 2 through 29, maybe. And the reason why I'm raising it is I understand the agreement that Mr. Wexler made yesterday was we, as far as admissibility of the exhibits, I'm a little bit hesitant to agree that they're all admissible without having laid eyes on the document. And so if we could just keep that agreement, and if you could give us possibly until Monday to confirm that we don't object to the admissibility of the documents, because I'm still, I can see 23 and 26 now, and I appreciate hearing examiner you putting those in. There's just other exhibits that I have not seen because of that process that Ms. Souls had laid out for looking at the documents that I couldn't get to work.
Right. And and I'll allow you some time,
Okay.
Miss Winter, or Miss Winter, Miss Olson, but really, I mean, she filed the stuff at the beginning of May. She filed her testimony and exhibit, so really, you should have looked at them before now, right? Or
Sure.
you should have let me know that you couldn't. But like I say, I'll let you have some time, and then you can make your proffer once we go on the record.
Okay, and I
Okay.
appreciate that. I think it's just what she's uploaded as the exhibits we haven't seen versus what was on her testimony, which I understand Mr. Wexler and others reviewed.
Okay.
And I'm assuming they're the same documents. I just can't say they are because I can't see them.
Okay. Right. But you understand, based on the information that I gave you yesterday, that you do actually have the ability to see them, right?
Yes, and I also understand from our paralegal, I think that she's seen them. For some reason, I just can't see them, and I haven't been able to physically connect with her so she can show
Okay.
me why she see them and I can't.
Yeah. Okay. No, I understand. Okay. If we don't have anything else, Mr. Lee, are we ready to go for day 4?
Yes, Your Honor.
Awesome. Good morning. We are back on the record. Today is day 4 of our hearing in case number 23-00046. And we've had an off the record discussion about exhibits and particularly confidential exhibits, which we will be addressing shortly at the time that the testimony is offered. I don't believe the other procedural matter, Ms. Winter, if you'd like to enter your appearance for the record, please.
Thank you, Madam Examiner. Nan Winter with Stelzner, Winter, Warburton, Flores, and Dawes on behalf of Doñana County.
Thank you. And welcome to the proceeding.
Thank you.
All right. I can also let the record reflect we still have not been notified by any person that wanted to give oral public comment in the case. I believe now we are at the point in our evidentiary hearing that our pro se intervener, Ms. Souls, would like to provide testimony to the commission. Ms. Souls.
Yes, ma'am. Madam Hearing Examiner, if you would take me there, please.
Mr. Lee, would you please swear Ms. Souls in?
Yes, Your Honor. Ms. Souls, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you.
Ms. Souls, you pre-filed direct testimony in this case.
Yes, I did.
And how was that identified?
That's identified as Souls Exhibit 1, the direct testimony of Mary Lee Souls on May 1st, 2024.
And you provided two different testimonies. One was a public version and one was a confidential version. Is that correct?
I provided my direct testimony, which was designated confidential because of some of the matters that it included. I also provided a redacted version of that same testimony that obscured any confidential information or references to it, and was appropriate for public viewing.
And the version of Souls Exhibit 1 that you placed in the Dropbox, is that the public version?
Madam Hearing Examiner, after further determination with the company and through your oversight, that is my original direct testimony that was designated confidential. All of the matters within it have been determined as not requiring confidential treatment, except for exhibits MLS 30 through MLS 50, which are still deemed confidential. Everything else has been accepted as appropriate for the public. So it is not different from the original confidential filing, except for those specific confidential exhibits.
So any of the numbers, primarily numbers, or anything that's indicated in red in your MLS Exhibit 1, you're asserting is not confidential. Is that correct?
No, ma'am, that's not quite correct. So this is a corrected testimony. So there are red-lined corrections that are in red throughout the testimony as it's been provided. There's also parts of the testimony that have numerical values that are portrayed in red to make it clear that they are negative values. So red within what is being offered here is no longer related to confidentiality.
Okay. So it either means corrected or it means negative.
That's correct.
Okay. And when you say corrected, it's my understanding, Ms. Souls, that you have filed some errata to that testimony.
Yes.
And the version that's in the Dropbox incorporates the errata that you filed since you filed your original testimony.
Yes, ma'am. Per your direction, these red-lined corrections reflect what was in the errata. There are a couple of additional corrections that as I did final proofing, I came across. I would also say that in the course of this hearing, there were a few things that came up that I would think still need to be corrected that are not yet redlined.
Okay. So you want to correct your testimony further? Is that what you're saying?
I believe that's appropriate. Yes, ma'am.
For what reason?
If you'll go to page 2 and beyond, I failed to change the headers to redline the confidential designation. There is testimony on page 35 and on page 52. It should also be corrected.
Let's go off the record for just a second. Mr. Lee, is it worth having another exhibit to get rid of the header? Do you believe that makes your...
Not to me, Judge.
Okay, what's the issue with page 35?
Are we on the record, Judge?
Oh, yes, I'm sorry. Let's go back on the record. Page 35.
Now. Yes. On page 35, at line 7, MPS 2 should be listed there. Line 7, MPS 2 should be on that list after the comma and before RG6.
Okay. And so why do you want to put that in now?
So in the course of Mr. Martinez's testimony, and as I was reviewing that, it was clear that I had made an error. I had caught that error in the exhibit, so the exhibit reflects MPS 2 as being not available for dispatch. and
Okay,
the
so when you're
text here in my
doing the
testimony didn't.
So when you were doing the analysis, then you included MPS 2. Is
That's
that correct?
Yes.
Okay. All right. What other changes, corrections, or
Also, on
deletions?
page 35 at line 10. So this is the corresponding list of what was available. MPS 2 should be removed.
Okay. So you want to remove it from line 10 and put it in line 7.
That is correct.
Okay. What else?
Page 52. At line 15, this is the same subject. MPS 2 should be removed after MPS 1.
Okay.
That is
Same
it.
reason?
Same reason. Yes, ma'am. It's
Okay.
all related.
Anything else?
No, ma'am.
I'm sorry, did you say delete MPS 2 on line 15, page 52?
Yes. She did. Miss Souls, with those, you have some exhibits to your testimony.
Yes, ma'am.
Uh, and basically you have, please identify what exhibits you have attached to your testimony.
Within the PDF that is Souls Exhibit 1 is MLS Exhibit 1. And then because of voluminosity, MLS Exhibits 2 through 4 and MLS Exhibits 12 through 29 are incorporated as part of my testimony. MLS Exhibit 30 through 50, which are confidential exhibits, are also included as part of my testimony.
And it's my understanding that exhibits 30 through 50, the confidential exhibits, are portions of data you received from El Paso Electric from their costing model. Is that correct?
They are the collection of costing models, yes, ma'am, that I received from El Paso Electric through Discovery.
and you utilized exhibits 30 through 50 to produce your testimony. Is that correct?
Yes, ma'am.
But you don't actually include anything that I have ruled is confidential from those exhibits in your testimony. Is that correct?
My testimony definitely relies on them. And the testimony that I've provided has been deemed and accepted by the company as not requiring confidential treatment. Yes.
But can you verify that the exhibits 30 through 50 that you've included with your testimony and have been put in the Dropbox are in fact the same MLS exhibits 30 through 50 that you filed with your testimony at the beginning of May? Do you understand?
I do. I'm troubled a bit because of the link that was not me but you that got them there. I can affirm that what I have provided is exactly what the company provided to me.
Okay, but you did not change. So you didn't change any of the confidential exhibits 30 through 50.
No, ma'am, I did not.
Okay. And the other exhibits were prepared by you or under your direction and control?
I prepared all of the exhibits. Some of the exhibits are similar to those confidential exhibits. They are specific data sets and descriptions provided by the company in response to discovery that I did not change, but included their collection of responses. Some of the exhibits is work that I created entirely on my own using information that the company provided.
And do you believe that the information contained in your testimony is as corrected and as corrected by you here today is true and accurate?
Yes, ma'am, I do.
And with the corrections, if you were asked the same questions that were contained in your MLS Exhibit 1, would your answers be the same?
Yes, they would.
Ms. Olson, based on off the record procedural discussions regarding exhibits, it's my understanding that El Paso Electric would like the opportunity, since I have placed the MLS exhibits 30 through 50 in a confidential Dropbox to which the parties have been given access. You'd like the opportunity to do a final review of those documents and would like until close of business on Monday to do that. Is that correct?
Madam Hearing Examiner, it's a little more nuanced than that. I guess
Okay, all right. Well, let me say this then. Is there any objection to what's been identified as MLS Exhibit 1, the corrected version
Excuse
of,
me. Are you referring to Souls Exhibit 1?
I'm sorry, I am, of Miss Souls Exhibit 1, her corrected pre-filed testimony, including her exhibits. Any objection to the introduction of Ms. Soul's testimony?
Madam Hearing Examiner, I don't think this is an objection, but it's a request for clarification as to a few of her exhibits.
Okay,
Oh, wait, let me see what, oh, maybe it's my problem that's under correct, the name is under corrected. I am looking for I'm not seeing on my download and on my screen. This is probably after trying to tell Miss,
okay,
Oh,
what's your
I'm,
objection?
I'm numbers 4, 10, and 11. Are they in the Dropbox? I mean, they weren't when I downloaded it, and I'm not seeing them right now, but maybe they just have a different name because they're corrected. Hold on a second.
Ms. Souls, did you put 4, 10, and 11 in the Dropbox?
Yes, I did. Look under
Oh,
corrected.
there I see 10. There I see 10 and 11 on this.
And there's
Maybe
4 right
I had a
there.
problem. Maybe I had a problem because of size myself.
And Madam Hearing Examiner,
Yes, ma'am.
I see 10 and 11. Looking for 4.
I
4
believe
is
I
on the
missed.
top of the screen on mine.
Top of the screen on
It
you.
was downloaded on the 23rd.
Okay. Let me see.
If I may, I misspoke earlier. I failed to identify MLS exhibits 10 and 11 are also in that list.
Oh, okay. So you said 12 to 29, 10 and 11 are there. Let me make sure I've got 10 and 11.
And for clarity, exhibits MLS 05 through MLS 09, those designations were not used.
Right. I saw that. I may have
What
an issue.
wasn't used? Excuse me, Ms. Stevens. What wasn't used?
Okay, got 10.
Exhibit MLS 05 through MLS 09.
So I just need to find 4. And you're saying it's there. It's okay. I apologize for, I guess I thought I downloaded.
Okay, any objection to what's been identified as Ms. Soul's testimony with, I believe I also want to say in the record that the 2 of the exhibits that Ms. Souls previously indicated as being confidential were determined not to be confidential, and I just renamed them in the Dropbox to take out the confidential designation, and they are MLS 23, which was the WEIM bids, and MLS 26, which I renamed as the RG8 overhaul. And those are in the Dropbox under this morning. Ms. Olson?
I have an objection and I have a request for a clarification.
Very well.
So my objection is that Ms. Souls has not laid foundation or established that she has knowledge to testify to the company exhibits to the extent she's offering them into evidence and including them with her testimony for the limited purpose of showing what she relied on to draft her testimony. I don't object to that, but I do object to the documents coming in as independent evidence because no foundation has been laid for a number of them. And then my request for clarification is, if you look.
Which exhibits? 30 through 50, is that?
30 through 50 and MLS 10, 11, 12, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, and 29.
And you're claiming that she hasn't put in a foundation to testify as to those particular exhibits?
That's correct. I believe when she was presenting her testimony, she said those are just documents that have been provided to her by the company, but she wasn't involved in preparing the documents and doesn't have direct knowledge of the information contained with those documents.
Anything further?
And then my request for clarification, for example, on MLS 11, when you open the document that's in Dropbox, it's just that cover sheet with the information on how to download it. And so I'm not entirely clear on what Mr. Lee intends to attach to the transcript and what would be the official record for this case in the event, say it went up on appeal. Is MLS 11 just this cover sheet, or does it contain some substance that is housed somewhere, ostensibly in Miss Sewell's Dropbox? I'm still not clear.
Ms. Souls, and pulling up MLS 11 that you placed into the Dropbox, it appears just to be the cover sheet.
Madam Hearing Examiner, there is content attached to that. If you'll give me a moment, I'll pull mine up from what I downloaded. Sorry about that. So when mine comes up, it has a paper clip on the left and it has 6 attached files.
Okay, and I think we've been round and round about this with regard to confidential documents. You see that you see.
Can you show me the paperclip you're talking about?
I am not seeing it on Madam Hearing Examiner's screen.
I think that might be my problem. I can't find this paperclip.
No, I appreciate that. And at this point, Ms. Stevens may be the one who has the best experience with this, because in the beginning,
Yeah.
when I was testing this, we tried to work through this.
Well, you can see that there's no Dropbox link for her to access.
This
And
is the weird thing. May I say something? Well, let me ask me when you're ready, because I do have the experience.
well, if there's no link to Dropbox, I don't know how she could get to the actual document, because Dropbox, or this particular version of the exhibit, she's right, it doesn't have any content.
Well, what goes on, the weird thing here is, and I don't ask me anything about computer wise why it's this weird, but, and again, I thought it had something to do with my old computer, but maybe not, is that when you download this and you open your downloads, don't stay in the Dropbox, but when you open your downloads, there will be a paper clip on the left, and you open it in Adobe Reader, I think. Is it Reader?
Right, but there's no
Attached.
link, Miss Stevens, to
Yes,
go
there is. When you do
download.
that. When you download, there's a link. That's the weird, I have no understanding of why it works this way. And I
Okay.
know that Ms. Souls worked with Melanie Sandoval at great lengths to deal with this, and somehow Records was accepting of that. And now that we've done this transition into Dropbox, it seems like something's been lost. And
Well, that's
the
enough. I
extent
don't
of
want to
my
hear
technical
anymore.
knowledge.
Thank you. There's no link to Dropbox, okay, on this document. So there's nowhere to go to download.
No, what I'm saying is when you go into Dropbox and you take we have the list in Dropbox, and you highlight this document, and you have the option to download the individual document, which you do. You have a somewhat different screen than I do, but you should be able to. Well, there's a download up there maybe that's it. You see in the very top, the second to the top toolbar, the little arrow under the box. I don't know whether that's going to work. It looks a little different on my screen. And this,
Okay. Well, we've spent enough time on this. Ms. Souls, if you can't, if we can't access your documents, or you can't tell us how to access your documents, then it's kind of unfair for the company to not be able to look at your document, right?
Madam Hearing Examiner, the company has had my documents since May 3rd.
Yes.
I have followed the instructions that were provided to me by Melanie Sandoval.
Well,
Some
Miss
people can
Sandoval's not
access-
here, so
I know. I don't know why Miss Olson hadn't tried to do this earlier, and I don't know why we weren't trying to do this, to figure this out back as early as last Friday. I can swear that document includes the appropriate attached files. I have no idea why it's not accessible right now.
okay. Ms.
Can I
Olson?
just respond? So I think I've figured it out. I appreciate all the direction. I downloaded it, and now I've found the paperclip. So I understand now
Okay.
how these documents are. I guess my concern is, again, that as Ms. Souls has said, these are voluminous documents. And so I guess from Mr. Lee, how these are reflected in the transcript. I've never done this before with these live documents. So say it's 1,000-page Excel spreadsheet. Does it just stay in the native format in Excel for the official record for this case, and then someone else would? Because I guess typically the transcript is a PDF, right? But here we're not talking about PDF, we're talking about native Excel spreadsheets that only live electronically. And so I just, if you're talking about a 12 gigabyte record for this case, I guess I just want to understand how that works.
My understanding is that previously, with regard, for example, to exhibits 30 through 50, the pink placeholder would be placed in the transcript, and if those 30 through 50 were admitted into the record, placeholder document would go in there, and the actual confidential Excel PDF to Excel remains at the commission on the flash drive. Okay, so I could only assume then that, and I honestly can't tell you. My assumption would be that if there were an appeal and the record was transmitted up to the Supreme Court, that a copy of that flash drive would go with. However, as to non-confidential exhibit, voluminous non-confidential exhibits, would that be similar, Mr. Lee?
Yes, Your Honor.
So, voluminous exhibits would have to go on a flash drive to Mr. Lee and would be transmitted back to the commission via flash drive. And I'll have to speak with Ms. Sandoval to find out about the access on that, and the IT people, because I don't think it would be posted on the website. I think you'd actually have to come here to the commission and look at the flash drive to do that. But that's all, that's all just my thought of how that would work. We'll have to, I'd have to verify that to you, but be assured that any voluminous documents are gonna have to be on a flash drive. And as I indicated, I believe yesterday to Mr. Wexler, the commission only has the one flash drive, and in this case, and it is in storage. So if you wanted to look at it, you'd have to make arrangements with Ms. Sandoval to do that, because she's not going to release it to you. Okay. It's the only copy. So she can't let the record away from the building. Did that answer that question, Mr. Rossi?
If you would like, I can walk you through how to open these.
Okay.
I figured
got
it
it?
out. Yeah,
Okay.
and I guess the short answer to my question is we have a flash drive with the confidential information, and it sounds like we need a flash drive for the voluminous public information. That's probably how it would be stored at the commission.
Yeah.
Okay.
Thank
that
you.
clarifies my clarification. Thank you.
Okay. Thank you, Mr. Rossi. Okay. Anything further to your objection, Ms. Olson?
No.
Ms. Souls, your response on the qualification, no foundation issue for various of your item exhibits 10, 11, 12, 18, 19, 20 through 29.
My response is that it's my understanding that we are seeking to create a record in this case. Obviously, most of the actual factual data and details come from the company. The company's rebuttal testimony did not specifically rebut by specific pieces of information or claims in my testimony. I would say I have not had a chance to establish a foundation directly with the sources of this information. I believe that the record would be incomplete and that could potentially create problems down the road if these exhibits are not admitted as part of my testimony, as foundation to my testimony, as the basis for the analysis that I conducted and the conclusions that I came to. It would erode the validity and the veracity of my testimony to not include this information.
Anything further, Ms. Olson?
I would just say that I think Ms. Souls is in agreement. She doesn't have foundation for the underlying information. And I think what I heard her say is it's included to show what she relied on for her testimony. And I don't have an issue with knowing that that information is in there to show what she relied on for her testimony. As I stated, it's the kind of truth or source of the underlying information that we don't have foundation for.
Madam Hearing Examiner, may I be heard?
Are you objecting?
I'm in a quandary here because in every commission case,
Are you objecting, Ms.?
I guess I'm objecting to the objection, I guess, or asking for
Okay.
clarification on objection. That's why I asked, may I be heard?
No,
Okay,
it's not your objection.
I know.
I'm going to overrule your objection, Ms. Olson. I think the fact that the type of administrative hearing that we have doesn't necessarily track with the court and evidentiary requirements. I think there has to be some flexibility in an administrative type proceeding. And also, just like with any other type of determination that's made on the evidence or on the credibility of the witness, the commission makes its determination on the best evidence that is offered and can assign the particular weight, if any, to the witness or any particular information that's offered. I think the attachments of some of the other witnesses that have been admitted in this case have gone through with no objection. And in that same spirit of allowing some leeway with regard to the technical rules, including some of Epe'S own witnesses that include orders from other jurisdictions. So it's my determination that I don't find that your objection to be relevant in this particular situation. Is there any other objection to Ms. Souls' pre-filed direct testimony? Hearing none. Ms. Souls, I'm going to admit your pre-filed testimony. Are you ready to answer some cross-examination questions?
I believe I'm as ready as I can be. Yes, ma'am.
All right. Very well. in our cross reservation time, I believe Ms. Olson, El Paso Electric has reserved 75 minutes. Please go ahead.
Thank you, Madam Hearing Examiner. Good morning, Ms. Souls.
Good morning.
Hopefully we won't take the full 75 minutes, but see how this goes. I don't want you to break Mr. Provencio's record. So in order to provide some context, I want to talk about the basis for providing your testimony this morning. And I'm going to start by talking about your interest in this case. So at the time you intervened, you represented to the commission, you're a customer of EPE whose electric rates will be affected by EPE's use and application of its fuel and purchase power cost adjustment clause, which I'll refer to as the Fppcac. Is that accurate?
That's correct.
And I want to look at page 5 of your testimony. Do you have that before you?
Yes,
In line 4 through 5, you list your address as being in Seattle, Washington. Is that correct?
that is correct.
And is that still your primary residence?
It is.
And how long have you lived there?
I think I've testified to this before. I am a pandemic refugee. So I came in the middle of the pandemic, 2020.
Okay, so approximately 4 years.
Reasonably, yes.
Well, the answer to this question is probably obvious. EPE does not provide service to your primary residence in Seattle. Is that correct?
That is correct. Though maybe through the WEIM, I understand Seattle Public Light is also a member of the WEIM. So I've maybe gotten a few of your electrons.
And nothing that happens in this specific case will likely impact your electric bill for your Seattle residents. Is that accurate?
Except for the WEIM, as I just referred. But yes, that is accurate.
And there's no direct consequence to that Seattle electric bill if EPE's Fppcac is or is not continued.
Not directly.
I believe at the time you intervened, you also stated that your ownership of property in Las Cruces creates a substantial indirect interest in this proceeding. Is that your recollection?
Yes.
And what property are you referring to?
I have a property in Las Cruces on Stagecoach.
Okay, is that property currently connected to an electric supply?
Yes,
And does EPE currently provide service to that location?
that's my understanding.
You don't know for sure?
That electric bill is not in my name.
Okay, so you don't pay for service at that location?
Not at that location, no.
And you don't receive service at that location?
That location does receive service from El Paso Electric.
You do not receive electric service at that location and you're not paying for service at that location?
I'm not paying for service at that location.
Okay, thank you. I want to turn now to the topics that are covered in your testimony. Can you go to page 8, please, of your direct testimony?
Yes, give me a minute, please. And where on page 8?
I'm I'm looking specifically on, starting on line 14. Are you with me?
Yes. Yes.
So in this question and answer, you're being asked for the purpose of your testimony. And after citing provisions of the Commission's Rule 550 and the Public Utility Act, you identify 3 disagreements. On page 11, line 11, you first disagree with EP's statement that its fuel clause Fppcac is consistent with provisions of the PUA. Is that correct? Public Utility Act.
I disagree with that statement, yes.
Okay, so that's one purpose of your testimony, is to disagree with that statement. And then, is that correct?
That is correct.
And then a second purpose of your testimony is to disagree with EP's claims that its policies and practices are designed to assure electric power is generated and purchased at the lowest reasonable cost. Is that correct?
I also disagree with that statement.
And then you list as your third purpose that you disagree with EP's claims that EP's current Fppcac has satisfied all requirements of the Public Utility Act, the Commission's Rule 550, and applicable Commission orders.
Yes, I disagree with that statement.
And then turning to further down on page 12, you identify the basis of these 3 disagreements. And you explain the basis of your disagreements is related to EPE's off-system sales and purchase activities, EPE's dispatch practices, and EPE's application of its discretion in determining that energy from Palo Verde Unit 3 was needed to serve New Mexico customers. Do I have that correct also?
Yes, you do.
And you'll agree with me that PV3 is no longer being used to serve New Mexico customers. Is that your understanding?
My understanding is that energy from Palo Verde Unit 3 has not been used to serve New Mexico customers since July of 2021. So for some part of this continuation filing and the period of which, and I'm not clear what the period is related to the continuation, but for some part of it since 2017, it was used to serve New Mexico customers.
And will you also agree with me that EPE's decision to use PV3 during the period it was used previously is encompassed within EPE's dispatch decision?
What do you mean by encompassed within? What do you mean?
That you could take that specific decision and put it in the bucket of dispatch decisions.
I believe that the use of energy from Palo Verde Unit 3 is a particularly unique case in and of itself, that it doesn't go in a bucket.
Sure, but do you agree that that's a dispatch decision? Or I might not be using the right technical terms because I'm a lawyer, but as a, trying to think of how to make it clearer, that goes within EPE's decisions of how to operate its system. It falls within that, that utility function.
It's my understanding that the non-Texas portion of Palo Verde 3, which at various times has been represented to me as 40 megawatts or 45 megawatts or some place in between. It's my understanding that El Paso Electric owned that amount of capacity, still owns that amount of capacity. And that non-Texas portion was never part of New Mexico rate base. And that therefore El Paso Electric had a piece of a generation resource that was not committed to the system, not committed to Texas, and not committed to New Mexico. And that therefore El Paso Electric would be making a set of decisions related to what to do with the energy from that capacity.
Okay, so you would agree it's a system operational decision?
I don't agree that it's a system operational decision. I think it's in a unique category all of its own that is not part of the system.
Okay, so your testimony is that the use of PV3 is separate from EPE's electric utility system.
Yes.
Okay. So I want to talk about your testimony on costs assigned to off-system sales. Can we agree generally that trading decisions are made, EPE's trading decisions, and I think generally trading decisions are made at the time the transaction takes place?
Yes.
And they're made based on the circumstances and information that's present at that time the trade is being contemplated or made?
I would agree with that.
So in your testimony, you give your review of trading decisions EPE made on 5 days out of the multi-year period. Is that accurate?
Yes. Let me say it a little bit differently, if I may. I used 5 days as illustrative. I'm not saying that they are exactly what happened in all of the over 2,000 days of the period that we may be considering.
So let me
They are
ask
illustrative examples.
So are they illustrative examples? Are they your analysis of what specifically happened on that day?
Could you ask the question differently so I understand the distinction you're trying to make?
Yeah, I had understood your testimony as this is my analysis of the events that unfolded on that specific day. But now I'm hearing you say you're providing these as illustrative examples. And so I'm wondering, I'm just asking for clarification. Was my first assumption that this is your analysis of what happened on a specific day based on the events that specifically happened on that day?
Yes.
And your review of each of those 5 days was after the fact based on the information that actually occurred on those days. Am I understanding that correctly?
Yes.
And your testimony analyzing off-system sales relies on EPE's costing model to review the trading decisions to engage in off-system transactions. Is that accurate?
The costing models were one piece of information that I relied on.
Okay, what were the other pieces?
The other pieces are mostly incorporated in the exhibits that I have offered. So I relied on information regarding actual sales and purchase transactions for the day. I relied on information regarding what generators were unavailable for dispatch on that day. There may be some others. I do describe it in my testimony as to what I used as the data and information sources in addition to the costing model for that day.
Okay, starting with the costing model, you did not create the costing model, correct?
I did not.
And you do not operate the costing model on a regular basis as part of your professional responsibilities, correct?
I do not.
And you've never traded power as part of your professional responsibilities, correct?
Correct.
And you've never engaged in reliability or economic sales of power.
What do you mean by that?
I'll skip that because you testified you've never traded power as part of professional responsibilities. As part of your testimony on off-system sales, you discussed the process for dispatch of resources, and I think you just testified you relied on dispatch of resources. Is that accurate?
Would you like to rephrase that question?
Part of your testimony on off-system sales discusses the process for dispatch of resources.
I don't believe it does.
Okay, let's look at page 42 of your testimony. Starting on line 6.
Yes.
And there you discuss and offer testimony on EPE's process for dispatch of its resources on March 5th.
I am commenting here, I believe, about Mr. Martinez's testimony regarding dispatch and how that relates to the evidence that I saw regarding what actually happened on March 5th.
Well, let's look at line 12.
Yes.
And can you read that first sentence?
I am concerned.
I'm sorry,
Excuse
man,
me?
can you speak up?
I am concerned as to why EPE dispatched 5 units instead of 2 units on March 5th, 2022. Operating 5 units instead of 2 units raises the required minimum amount of local generation, much of which EPE customers do not require, thereby increasing the amount of gas-fired generation that must be sold off-system at prices below the cost of generation.
And will you agree with me that that is your opinion on how EPE operated or dispatched its resources that day?
No, ma'am. That is my testimony regarding the impact of those dispatch decisions on the costs and the implications of how those costs affect EPE customers.
Okay, will you agree that this statement relies on your testimony that customers did not require that generation? That's your conclusion, not EPE's?
I'm not prepared to agree to that. I would agree that this is not necessarily EPE's conclusion, although EPE did not rebut this directly. So I don't know what EPE's conclusion is. But I do stand by that the generation was not needed by EPE customers because it was sold off system. So
Well, who
not,
just, I'm sorry, Ms. Souls, go ahead.
so by not needed by EPE customers, it was not to serve native load. It may have been used for reliability purposes. And I don't believe there's anywhere in my testimony that I suggest that reliability purposes are unimportant.
Well, who decided, in your answer here, who decided 2 units?
I suggested the possibility of 2 units. Nobody decided 2 units. El Paso Electric, in fact, decided on 5 units.
Right, but in your answer, you say they dispatched 5 instead of 2. Where did you come up with the 2?
I came
your
up with
answer.
the 2, yes, ma'am, through the calculations of what is required by native system load directly. This is, so I learned something in this hearing. Mr. Trethaway yesterday talked about unit commitment and testified that it should be based on reliability and economics at the same time. So my testimony is trying to highlight the economic impact of 5 units instead of 2 units. And this piece of the discussion is all related to hypothetical. It was never intended to say, I know this could be done. It was intended to say, if it could be done responsibly, reliably, it is a better cost outcome for customers.
Thank you, Ms. Olson.
So Ms. Sills, based on what you just testified, you don't know whether this scenario could be done.
I don't know that. I am not a electric system dispatch expert. I would not claim to be. I hope this isn't represented as I think I am. I am not. I am trying to reflect the economic impact of commitment and dispatch decisions on El Paso Electric's customers.
Okay, thank you, Ms. Sills. That's all the questions I have for you. Appreciate your time this morning.
Thank you, Ms. Olson. Ms. Winter, I believe Doña Ana County reserved 5 minutes. Do you have any questions for Ms. Souls?
Madam Examiner, we do not.
Very well, thank you. Ms. Stevens, I believe that City of Las Cruces reserved 10 minutes for Ms. Souls.
The city doesn't have any questions for her. Thank you, Madam Hearing Examiner.
Thank you. And I do not believe Mr. Black, Mr. Rossi, that the staff reserved any time for Ms. Souls.
You are correct, hearing examiner.
Okay. just want a little, good morning, Ms. Solz.
Good morning, Jen.
I've got some questions, and I just want to clarify in my mind, and I want to go back to this question on page 42 that Ms. Olson was asking you about. And so what I took away from this is that you were posing a hypothetical to try to look at the economic impact primarily of dispatch decisions.
Yes, ma'am. My testimony for each of these 5 days is starts with a target of 3 different levels. The first has to do with no changes. This is what El Paso Electric did and how they costed off-system sales, which leads El Paso Electric to continuously represent that they're making margins, profit in positive numbers, when I don't see that at all. And I'm not saying that they shouldn't make negative margins, that they shouldn't make sales below cost when they have to do that. I think that is part of the reliability premise when system load is very low. But portraying that as a profit is not helpful to anybody. The second level has to do with where they commit the same units and generate less, which would mean that they would sell less at a loss and thereby also reduce the costs to customers. The third level is this hypothetical, which is related to the commitment decisions that El Paso Electric made. So this particular testimony here is that hypothetical part. I don't know that they could do that, but if they could, it would be economically valuable to their customers.
Okay. So it would even be more economical if they could just dispatch one unit, right?
Possibly. There's a
Right?
point, as Mr. Bustillo said yesterday, there's a point where it just doesn't make any sense. So I would have started in my naive, non-expert way of saying, yeah, I'm pretty sure I want 2 units running, one of which is a big thing that's flexible, and one of which is these quick start, fast ramp, quick down, that are of the ones they did dispatch the most economical. So my limited notion of reliability said, well, at least 2. But that is not based on I believe or I know that this is possible. It is a suggestion that if it were, it has economic value.
And do you think your testimony would have been any different after hearing from El Paso Electric's witnesses, and especially Mr. Martinez and Mr. Bustillos, about the way that that the decisions are made and the components of reliability? Did you find that informative?
So frankly, Mr. Martinez and Mr. Bustillo's rebuttal testimony, I found very, very helpful. My conclusions, with the exception of costing, are that we're not much misaligned. I believe I started from many of the same principles. Mr. Bustillo's testimony was the first time I have heard or read El Paso Electric talking about unit commitment and their security and reliability practices. I'm very reassured that Mr. Bustillos loses sleep over things like that.
Yeah.
And I am still concerned that I'm not hearing how the economic pieces of those decisions factor into the trade-offs that are inherently built into that. That there should be a tension between, do you really need 5 or can you do it with 4? And I know that's not as reliable, but 5 isn't as reliable as 6. So some trade-off is being made there anyway. There ought to be that tension.
But you did find informative, didn't you, the El Paso Electric testimony of especially the different potential constraints and how they have to compensate for a whole lot of things other than just what the cheapest product is, don't they?
Of course they do. Yes.
I agree with you. I found it to be informative. And so let me look. I think when Ms. Olson was talking with you about the purposes of your testimony, am I correct in understanding that your hypothetical, that your analysis and your hypothetical analysis of El Paso Electric's policies and procedures are the basis for your recommendations regarding the continuation of the FPPCAC?
No.
No, that's not correct.
No. I make recommendations about the costing model.
Yes.
The costing model. Go ahead.
Oh, but you also make recommendations about that the FPPCAC shouldn't be continued, right?
I do. The FPPCAC, Fuel and Purchase Power, says nothing about sales. And sales have become a huge part of El Paso Electric's economic activity. In addition, there were examples through 2022. In my analysis, I believe this was reflected mostly in the May 14th, 2022 and the August 15th, 2022. Those were expensive days for El Paso Electric customers because of purchase power. So way back when I first started participating with El Paso Electric through its integrated resource planning public advisory process, the FPPCAC was represented to me as the mechanism whereby the variations in fuel that are happening immediately and all of the good reasons about immediate changes for customers and for the company as circumstances changed, and that purchase power was included because it was part of providing energy to customers. Never said anything about sales, and yet sales is driving fuel costs and it's driving purchase power costs. In addition, the purchase power in the days that I analyzed appeared to be more because of operational difficulties. So on May 14th, one of the Palo Verde units was still down longer than it was forecasted to be down, removing a huge chunk of generation. Rio Grande 8 was still down for its major turbine overhaul that took a lot longer than had been planned. And then there's another generator that was down for inspections that I had understood from Epe'S responses that perhaps if we had talked about it, they would have represented differently, but that it read to me as it was discretionary. And because of that, El Paso Electric did not have enough local generation on May 14th, and they engaged in purchase power, and purchase power was expensive on May 14th. For August 5th, the other one was, and the renewable energy PPAs didn't come to pass. So the new generation that was supposed to be all related to renewable energy, for various reasons, it didn't come online. The result.
But how do all these things relate to your recommendation that changes be made to the Fppcac specifically?
It's the sharp pencil principle, which is the Fppcac is currently running open loop. And customers pay for it directly. It means that even though El Paso Electric is engaged in a number of operational decisions and challenges and project failures, that the costs of those not coming to pass as planned and represented are borne directly and immediately by El Paso Electric customers.
Well, specifically in your summary of your conclusions and recommendations, you testify that EPE has decidedly not met regulatory requirements for continuation. That in multiple significant ways, EPE's policies and practices fail to assure that electric power is generated and purchased at the lowest reasonable cost. I have demonstrated that these policies and practices are designed for this failure to assure that electric power is generated and purchased at the lowest cost. That's your testimony, right?
What page you on?
The version that I have, it's your summary, section 9. And it's answering the question, please summarize your conclusions and recommendations.
On page 128?
Yes.
Okay. I'm sorry. Could you go again? I was trying to catch up with you and I didn't do it quickly enough.
I was referring to your testimony beginning on line 12.
Yes.
So basically you're saying that EPE doesn't comply with the requirements of the FPPCAC, right?
Yes,
And you're saying that EPE's policies and practices are not designed to comply with the
Yes.
requirements of the FPPCAC, correct?
yes,
And you make some recommendations, including taking off-system sales out of the FPPCAC, correct? Purchase
That is-
power, I'm sorry. If you look at page 134.
purchase power, yes, ma'am.
Yep, regardless of any other step the commission may take regarding the request for continuation, I am recommending that EPE no longer be permitted to recover the cost of purchase power through the FPP CAC mechanism. Correct?
Yes,
So you would turn the FPP CAC into an FCAC.
or a cost and sales, yes.
So do you have any? And then I guess you would rely or El Paso Electric would have to rely on for recovery of the purchase power, collecting that through a rate case. Is that right?
I believe that's correct.
So did you, in your research and analysis, did you look at any of the other IOUs to see how their FPP-CACs operated?
No, ma'am.
Do you think it would be fair if the other utilities are allowed to recover purchase power through the FPP-CAC pursuant to Rule 550 and the statute, to allow them to do this and to not allow EPE to do this? To not allow EPE to do this and to allow the other utilities to recover purchase power through the FPP-CAC?
I do not understand the concept of fairness on this topic. I think it is not fair to EPE customers that EPE can purchase power at high cost whenever it's convenient.
Okay. In addition to your recommendations, Ms. Solt, you've called for, and I don't know, please explain to me, are you calling for multiple prudence reviews or just one big one?
Madam Hearing Examiner, there's been various conversations about my expertise or qualifications for this. I do not feel qualified to answer that question. I believe there are a number of topics appropriate for such a review, requiring such a review, but I don't have an opinion as to whether or not that should be a single prudence review or multiple prudence reviews. I would certainly leave that to the commission and whatever processes would make that determination.
So, for example, on page 132, and that's still in your conclusions and recommendations. I am recommending, this begins on line 2, page 132. As a result, I am recommending that the commission initiate a thorough investigation as to what parameters and decision criteria are actually incorporated in EPE's security constrained economic dispatch mechanism. Among other things, such an investigation should include a determination, and then you've got 3 points. Correct?
Correct.
So when you say investigation, you is that synonymous with prudence review?
I think it could be, but I don't know that that's required.
Okay, so you think that could just be an investigation by the commission?
I think that's possible.
Okay. And then at the bottom of the page at line 19, I am recommending that the commission initiate a prudence review of EPE's actions regarding EPE's discretion into the non-Texas portion of PV3. And you go on to the next page, energy and capacity to serve New Mexico customers. A prudence review should, and then lines 3 through 16, you have what you think should be included in that prudence review, correct?
Correct.
And then you say at line 18, if the commission determines that there is imprudence on the part of El Paso Electric, I am asking the commission to look even further back than 2017 to determine the full scope of and impact of EPE's imprudence. That's your testimony?
That is.
Like how far back? 1950?
No, ma'am. It didn't go back that far.
Okay. Back to when?
It could go back depending on the commission's findings. It could go back to when the stipulation that set up the proxy price was first initiated. But I would tell you, ma'am, that I'm not familiar and wouldn't claim to be with the history of this earlier than 2015.
So you're targeting approximately when, what was it, 27, 22 was the case? Approximately.
I thought it was in 2009.
Yeah.
And again, I'm not going to claim to be an expert on this.
Okay. Then, in addition, on page 34 at line 17, you say, finally, I am recommending the commission exercise its discretion according to the provisions of 550-19 and order refunds of inappropriate charges collected under the FPPCAC for the period of time of 2017 through 2022. That's your testimony?
It is.
So what type of proceeding are you envisioning that the commission would do? The action regarding refunds that you're talking about?
Again, I wouldn't pretend to have expertise in that. I see the Public Regulation Commission of New Mexico as the protector of El Paso Electric's New Mexico customers, and that therefore I would rely on the commission to make those determinations. And Madam Hearing Examiner, I believe that last question, you were referring to page 134 and not 34. Is that correct?
Yes, 134,
Thank you.
continuing on to 135. Oh, page 28 of your testimony,
Give me a minute, please.
you are responding to a question that was posed on page 25. That's line 17 through 19. That says your MLS1 illustrates the dollars that are flowing through Epe'S Fppcac related to off-system sales. Did Epe'S customers benefit from those off-system sales? And I want to ask you about the part of your answer. You're on page 28, you're referring at line 11 to Mr. Martinez's testimony. And at line 11, you say, therefore, I note 3 caveats to the simple premise regarding opportunity sales. That, and then you list the 3, what you've referred to as caveats. Is that correct?
That is correct.
Where do those come from?
These come from my experience in the realm of pricing and how that relates to cost and sales and profitability in a world that is not regulated. Now, as I'm looking at this, I would also note that the third caveat is that answer doesn't apply to, because it's related. It says opportunity sales based on natural gas-fired generators is counter to New Mexico's goal of seeking to reduce dependence on fossil fuel-based generation. That would be based on my experience directly within the world of New Mexico energy and activities at the legislature and the efforts towards renewable energy and the Energy Transition Act.
So is it your recommendation that El Paso Electric get rid of all of its New Mexico or all of its natural gas generation and replace it with renewables, and that the El Paso Electric ratepayers pay for that?
It is my understanding that the New Mexico legislature has set exactly such a goal.
I believe, Ms. Souls, that's questions I had for you. Um, oh, no, I did have one more question, actually. Your testimony on page 112,
Give me a
you
minute,
reference
please.
the question posed at line 5. What information did you have for minimum operating levels? And at line 16, you are you reference the EPE WEIM bids, which we've talked about earlier. Is that information is contained in MLS 23? Is that correct?
Correct.
With regard to El Paso Electric's performance in the WEIM, you heard the characterizations from some of the joint Doña Ana County City of Las Cruces witness, didn't you?
I did.
There were some pretty positive discussions on EPE's performance and the metrics performance tests utilized by the WEIM, correct?
I heard that, yes,
Do you believe it?
I do.
You think that's a positive for El Paso Electric? Or could be?
What I understand of the WEIM, I am optimistic about it being positive for El Paso Electric and El Paso Electric's customers. And what I heard in Mr. Trethewey's testimony leads me to be even more optimistic regarding that. So I think it's a positive.
Very well. Ms. Souls, that's all the questions I have for you. I think now might be an appropriate time for us to have a break, and then I'll give you the opportunity to think about if there's any redirect that you want to put in based upon the questions, and I'll give you an opportunity to do that when we come back. I have 10:48, so we'll come back at 11 and continue. So again, we're on the YouTube, so I just remind people of that. It's gonna keep on going, and we'll resume at 11. Thank you.
Mr. Black, do you know who is offering Mr. Malden?
That would be me.
Thank you, sir.
You're welcome.
Okay, I think we are back from our morning recess. Ms. Souls, any in redirecting yourself, is there anything else you'd like the commission to know?
Yes, ma'am. Thank you. So Miss Olson was asking me about where I reside in electric service. She failed to ask me if I was a customer of El Paso Electric. For the record,
Okay.
I'd like to note that I am a customer of El Paso Electric. Receiving service at 5054 Silver King in Las Cruces. And that bill also has the address of 1401 Juniper Avenue, also in Las Cruces.
Okay, so you're getting service at 2 locations in Las Cruces?
It is on the same account.
Okay.
And yes, I am a customer of El Paso Electrics.
Okay. Very well. Anything else?
Yes. Throughout my testimony, I refer to security constrained economic dispatch, which was the term that Mr. Martinez had used. And I had understood that to encompass the whole realm of unit commitment, as well as the dispatch of those units that are committed. So with Mr. Bustillo's rebuttal testimony, I have a clearer understanding of that. And I would like to clarify that the dispatch portion of my testimony is generally related to the middle part of the analysis related to appropriate sales or purchases. And that unit commitment would be what I understand to be related to the hypothetical analysis. And those terms in that distinction have much more clarity with the rebuttal testimonies and with the testimony offered by Mr. Trethewey.
Okay.
And that's all. Thank you.
Thank you, Ms. Souls. Ms. Olson, anything further?
I do have brief follow-up on Ms. Souls' redirect.
Okay.
Ms. Souls, I think I asked you during direct examination if you had paid any EPE electric bills, and I thought your answer was no. Is that not accurate?
I do not recall you phrasing any of your questions that way.
Okay, let's back up then. So you testified on redirect that you are a customer of EPE, is that accurate?
Yes, I believe I also portrayed that in my application for intervention.
Sure. And the basis for you claiming to be a customer is that you receive electric service at 5054 Silver?
5054 Silver King.
Silver King?
Correct.
And you also receive service at 1401 Juniper?
That is correct.
Do you reside at either of those locations?
I do not.
Who does?
Family members.
Okay. Are the family members that reside at those locations listed on the account for that service?
Yes. No. The name on the account does not reside at either of those locations.
Okay. Are you the only person listed on those accounts?
I am not.
And where are the electric bills for those accounts sent?
I believe they're sent to 5054 Silver King.
So the bills are sent to that location, but the person who resides at that location doesn't pay the bills? And isn't listed on the account?
I think that's a true statement.
Okay. How many days in the last year have you spent at 5054 Silver, or nights have you slept there?
Madam Hearing Examiner, can I object to this line of questioning? Since I don't have
Sure.
an attorney
Why don't you
representing
wanna
me,
know?
I'd like to object.
Sure, you'd like to object, why?
I'd like to object as relevance.
Okay. Ms. Olson?
Well, Ms. Souls is claiming or representing to the commission she's a customer of El Paso Electric Company and that her interest as a customer is being impacted in this case. And I'm trying to understand what she means by a customer and whether or not she's actually been present and resided at any time during the last year at the location where she's claiming to take service, I think is relevant to whether her electric service is being impacted by this case or the electric rates are being impacted, why her interest in electric rates is being impacted by this case.
Well, I think some inquiry regarding the nature of why you think you're a customer is appropriate, Ms. Holes. So, gonna overrule your objection, but would ask you, if you live in Seattle, but your name is on the account, you've testified that your name is on an El Paso Electric account for property that you own, is that correct?
That property is family property,
Okay,
and I am financially responsible for that account. And I don't believe Ms. Olson has laid any groundwork that one has to be physically sleeping for a certain number of days in a particular location in order to be financially responsible.
right, but so you're indicating that that your name's on the account, it's a family property, and you're financially responsible for it, right?
That is correct.
Right, but you don't reside there.
I don't reside there. I have not claimed to reside there.
Okay, Ms. Olson?
Ms. Souls, you're claiming you're financially responsible for that account, but you don't receive the bills, I think was your testimony, is that correct?
I did claim that I'm financially responsible for that account. I don't receive those bills directly, no.
And how many of the electric bills for that location have you paid in the last year?
Again, I'm going to object, Madam Hearing Examiner. The financial arrangements with me and my family and my tenants, I don't see the relevance. And Ms. Olson hasn't established the relevance to whether or not I'm a customer of El Paso Electric.
Ms.
Madam
Olson?
Hearing, I respond. I am trying to understand what she thinks being a customer means if she doesn't
Ask her that question then.
service. Well, I first need to establish, I've established she doesn't use any electricity from that service. And now I'm trying to establish whether or not she's paid for that service. And so the question I've asked is, has she paid any of those bills? And then if
Ms. Souls?
the answer,
I have not directly paid any of those bills out of my personal checking account.
Ms. Olson?
I asked, how many of those bills have you paid?
She just answered you. Ask and answered. Move on.
Okay. So, Ms. Souls, your testimony has established you don't receive service and you don't pay for service. So what does being a customer mean to you?
I receive service at those locations that I previously identified. I am financially responsible for paying for the service received at those locations. I am a customer of El Paso Electric's. I believe that you can go into El Paso Electric's files and records and find verification of each of those facts.
Ms. Olson?
So if I understand your testimony correctly, your name is listed on the account, but you personally do not use the service and you personally do not pay the bills. Is that correct?
What exactly do you mean by use the service?
Well, you've testified you don't reside at that house, so I'm assuming you're not using electricity at that location, you personally.
Madam Hearing Examiner, I object as to relevance and foundation.
The foundation for the question is your claim to be a customer. I'm trying to understand whether you personally.
I think
use-
she answered that, Ms. Olson.
Okay,
Move on.
I'm done.
Okay. Anyone have any further questions? Hearing none. Ms. Souls, thank you for your testimony. Commission appreciates its pro se interveners as much as we appreciate our other participants in the case. However, I realize that to have an individual make the effort to participate in the commission's proceedings is hopefully a positive experience for you. Thank you.
We can talk about that at some point.
Thank you. Anything further from you? All right, you're excused, ma'am.
Thank you.
Mr. Black, I believe that we're ready for the staff presentation, and I thought I heard you tell the court reporter that you will be presenting the staff witness. Is that correct?
Yes, I am presenting staff witness Jonah Malden.
Very well. Looking in the Dropbox. While we're waiting for Mr. Malden, there he is. Parties can be thinking about dates for any proposed post-hearing writings after the conclusion of the evidentiary portion. I will talk about a couple of briefing issues that I have in mind for the commission in this case. Hello there, Mr. Malden.
Madam Hearing Examiner, may I ask Mr. Black a question about what's in the Dropbox? Because they've added two things now. Are these replacements for both exhibits? Is it what you're gonna be using?
The first one was a
Uploaded an hour
mistake.
ago.
The first one was a mistake. The second one I labeled replacement.
Oh, okay. So the first one that went up today, forget about just the second one?
The first one was a mistake.
The first one from an hour ago or
The first one is a mistake.
today's first one is what I'm asking. Is that what you mean?
I didn't upload anything else ever. The
Oh.
first one I uploaded is a mistake. I don't understand why you don't understand that.
No, because I just opened the Dropbox, went to modified by, and I see two documents, one that says
Your
staff
Honor.
exhibit one red, and one says replacement staff, and they're two different, they're about the same size. I haven't opened them both. I'm just trying to figure out whether.
Let's wait till he calls the exhibit, Miss
Okay,
Stevens, and
okay.
maybe it'll become more clear.
Maybe
Good
it will
morning,
be
Mr.
different.
Malden.
I'm
morning.
trying to figure out what I
How
need.
are you?
I'm good. How are you?
I'm okay. You're probably hoping to benefit from the Friday last witness. We want to leave questioning philosophy, aren't you?
I guess we'll see. Yeah.
Yeah, exactly. Okay, very well. Mr. Black, you have a witness, sir.
Thank you. Mr. Lee, could you please swear the witness?
Sure. Malden, would you please raise your right hand? You solemnly swear the testimony you're about to give is the matter of, and you should be the truth, the whole truth, nothing but the truth.
Yes, I do.
Mr.
Thank you,
Black,
sir.
thank
Thank
you.
you. Thank you, Mr. Lee. Thank you, hearing examiner. Let's see. Good morning, Jonah Malden. How are you? How are you today?
Doing well. Thank you.
Okay. For the record, please state your name and position with the Public Regulation Commission.
My name is Jonah B. Malden. I'm the Accounting Bureau Senior Economist at the New Mexico PRC Utility Division.
And PRC is the Public Regulation Commission.
Yes, sir.
Thank you. Do you have in front of you a document that is marked as, what did I mark it? As Staff Exhibit 1 in black, hyphen, in red, redlined with errata?
Yes, I do.
Okay. What is that document?
That is my prepared direct testimony in this case with a correction that was filed via an errata.
Okay, we'll get to that. That will be Staff's Exhibit 2. What is the correction?
It is on page 21, which I believe is PDF page 23. And then line 12 through 13, the sentence has a erroneous phrase that is taken out and is shown in red line. And the phrase that should be taken out is the same figure shows.
Can you read what it should be saying, please?
Yeah, yes, so the sentence starts on line 12 and it should read, as of December 2023, EPE has had a cumulative under recovery of $2.2 million.
Thank you. Do you have any attachments to your to this testimony?
Yes, I have two exhibits. The first being supplementary data to my analysis, and the second being an explanation for one of my analyses that I performed.
Thank you. Were those exhibits to your testimony created by you or under your supervision?
Yes, they were.
All right. Do you have any corrections to those exhibits?
I do not.
All right. Was the complete testimony drafted by you or under your supervision?
Yes, it was.
All right. If I were to ask you the questions that are posed in this testimony, would you give the same answers today under oath?
Yes, I would.
Is your testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
Hearing examiner, I offer Staff Exhibit 1 redlined with errata into the record.
Any objection to what's been identified as Staff Exhibit 1 redlined with errata the prepared direct testimony of Mr. Malden as corrected and verified by him here today. Hearing no objection, staff exhibit 1 is admitted. Mr. Black?
Thank you. Mr. Malden, do you have before you what has been labeled as staff exhibit 2?
Yes, I do.
Was this testimony drafted by you or under your supervision?
Yes, it was.
Are there any exhibits to that to that errata?
No, they're not.
Okay. Do you have any corrections to the errata?
I do not.
All right. And can you just explain what the errata is?
The errata has the paragraph excerpt from my direct testimony that shows the line or the phrase that should have been struck on lines 12 and 13.
Okay, thank you. And which shows up in the red line version of the staff exhibit 1?
Yes.
Okay. Hearing examiner, I move what has been marked as staff exhibit 2 into the record.
Okay. Potentially, we could have dispensed with that, but any
What?
objection to what's been identified as staff exhibit 2, the actual errata to the corrected red line version of staff exhibit 1? Hearing no objection, staff exhibit 2 is admitted. Mr. Black?
I appreciate that. Thank you, Your Honor. Mr. Malden, do you have before you what has been labeled as staff exhibit 3?
Yes, I do.
All right. Was that exhibit compiled by you?
Yes, it was.
Is it true and correct to the best of your knowledge?
Yes, it is.
Are you aware that the contents of this exhibit has already been admitted from under the Doña Ana County exhibit number 3?
Yes.
Okay, Your Honor, this might be redundant, but staff would like to move staff's exhibit 3 into the record.
Yeah, I think it probably is.
I'm going to object to this one because it's already in the record, and I don't think that if he's using it proactively or if he's using this to supplement his direct, that's not appropriate.
Mr. Black?
I don't know what the use is.
Yes, as a matter of convenience, should any cross-examination questions come up, that's what the purpose of this exhibit is.
Well, Madam Hearing Examiner, then I would wait until that moment arises. I don't see the point of admitting it, again, kind of preemptively at this point.
Mr. Black, anything further on this?
We can refer to Doña Ana County exhibit 3. We're
Okay.
fine with that.
All right.
So we'll withdraw staff exhibit 3.
Okay, go ahead, sir.
Mr. Malden, do you have what's before you been marked as staff exhibit 4?
Yes, I do.
Was that exhibit compiled by you?
Yes, it was.
Is it true? Is it a true and correct copy of what it represents to be?
Yes.
Okay. Are you aware that the contents of this document have already been admitted into the record as CLC Exhibit 1 as an attachment to Jose Provencio's direct testimony?
Yes.
Okay. Your Honor, I move admission of staff Exhibit 4.
Madam Hearing Examiner, I raised the same objection. And in terms of the convenience argument, I do have questions. I do have this labeled as a city exhibit that I expect to use in my cross-examination. But at this point, it's premature and inappropriate for staff to be supplementing their own testimony.
Your Honor, I would like to interpose that this is kind of a rule of completion is what's going on here.
I believe that this particular exhibit was answered by Mr. Malden after his testimony.
No, I think both of them were, well, I should need to go check.
Mr. Black?
Mr. Malden, can you refresh my recollection on that? I think the hearing examiner is correct.
You're right. Yeah, it was.
Ms. Stevens, I'm not talking to you. All right, so you need to withhold your comments. I'm asking Mr. Black, it's his exhibit.
Yes.
Okay, I'm going to sustain the objection then, because this is staff. Well, no, it's not part of his testimony. It's already in the record.
So we'll withdraw it.
All right, go ahead, sir.
Thank you. Madam Hearing Examiner, Jonah Malden is available for cross-examination at this time.
Very well. Ms. Olson, I have 0 to 10 listed in your reservation of questions. Does El Paso Electric have any questions for staff?
Good morning, Mr. Malden. I'm gonna go with the 0.
Okay. I don't know. I never wanted a 0 on anything. But your choice, Ms. Olson. Ms. Winter, I believe that Doña County had 15 minutes reserved. Do you have questions for Mr. Malden?
Very few, Your Honor.
Please go ahead.
Thank you. Good morning, Mr. Malden. My name is Nan Winter. I am with Stelzner, Winter, Warburton, Flores, and Dawes, and I am Mr. Herman's law partner. I have a few questions for you this morning, very few. Can I direct your attention to what has now been downloaded as Doña Ana County Exhibit 2 in the Dropbox? Can you locate that and tell me when you're there?
Okay, I have it open.
All right, thank you. Can you confirm on the record for me that this is staff's response to city interrogatory request for production 2-5?
Yes, it is.
And do you recognize this exhibit?
I do.
Okay, and if I asked you the questions that were propounded in this interrogatory, would your answers remain the same?
Yes, they would.
And are your answers still true and correct?
Yes, they are.
And you responded to this just a little over a month ago on May 22nd, is that correct?
I don't remember the exact date, but that sounds about right.
All right, thank you.
Look at the screen. Mr. Malden,
Oh, okay.
does that refresh you?
Yes, May 22nd. Yes.
Thank you, Ms. Winter.
With that, Your Honor, I would move the admission of Doña Ana County Exhibit 2.
For what
Any
purpose? I'm sorry, Ms. Winter, I'm just asking for what purpose?
I mean, it's his response, and it'll be brief, but we now are subject to further cross-examination on this exhibit.
Mr. Black, objection?
That's fine.
Any objection to what's been identified as Doña Ana County Exhibit 2? It's the interrogatory response of Mr. Malden. Hearing no objection, Doña Ana County Exhibit 2 is admitted. Go ahead, Ms. Winter.
Thank you, Your Honor. Mr. Malden, with respect to Exhibit 2 and prior to your formal response to this interrogatory on May 22nd of 2024, did you contact EPE via call or email or any other method before responding to this particular request for production?
Yes, I believe I did.
Okay, and who at EPE did you contact?
I spoke with Miss Reza as well as I believe Mariah Novella.
And what was the form of that contact?
It was via a Teams call.
And how many Teams calls did you make when you were coordinating with Miss Reza and Miss Novella?
I was not coordinating with them for any responses, but we spoke once before this response.
And what was the purpose of the call then?
The purpose of the call was to discuss the February 2023 billing error and to illuminate staff as to what happened.
So is it your testimony that the call with Miss Reza and Miss Novella had nothing to do with your responses in what is now marked as Doña Ana County Exhibit 2?
That is correct. I prepared these under my own
All right.
directive.
All right, and thank you so much. Mr. Malden, I would now direct your attention to what has been downloaded into the Dropbox and marked as Doña Ana Exhibit DAC3. Can you take a moment and locate that exhibit for me?
Okay, I have it open.
And would you confirm for me that this is staff's response to county interrogatory request for production 1-1?
Yes.
Your Honor, it also has DAC 1-2 included in that exhibit. Or that could be an attachment, I don't know.
Correct. Thank you, Mr. Black. Appreciate that. Mr. Malden, do you recognize the exhibit?
Yes, I do.
And again, can you confirm that this is staff's response to county interrogatory request for production 1-1 and 1-2?
Yes, I can.
If I were to ask you the same questions that were propounded in this interrogatory, would your answers remain the same?
Yes, they would.
And would your answers still be true and accurate?
Yes.
Your Honor, with that, I would move the admission of Doña Ana County Exhibit 3.
Any objection to what's been identified as Doña Ana County Exhibit 3? Mr. Malden's response to DAC 1-1 and 1-2. Hearing no objection, Doña Ana County 3 is admitted. Ms. Winter?
Mr. Malden, did you contact EPE via call or email or any other method before responding to what has now been marked as Doña Ana County Exhibit 3?
I did not contact EPE, no.
There was no coordination with EPE on your part with respect to the filing of this response?
I object, Your Honor. He already answered that. He said he's not coordinating with EPE. Rephrase the question, please.
Well, Mr. Black, I believe it hasn't been asked and answered. I think he said he didn't contact via, hang on. I'll look specifically. I don't believe that he answered the question as you phrased it, Mr. Black. So I'm going to overrule the objection and answer if you know, Mr. Malden.
Can you repeat the question, please?
Did you coordinate with EPE with respect to your response to what has now been marked as Doña Ana County Exhibit 3 in any way?
I did not coordinate my response. My response was formulated by myself.
All right, thank you, Madam Examiner. No further questions for Mr. Malden.
Thank you, Ms. Winter. Ms. Stevens, I believe that you reserved 40 minutes for questions for Mr. Malden. Please
did,
go
and
ahead.
I hope it's not going to take that long. I suspect Mr. Malden hopes so even more than I do. Good morning, Mr. Malden. How are you?
Good morning. I'm doing well, thank you.
I'm Anastasia Stevens on behalf of the city. And I want to start with, were you watching the hearing on Tuesday when your attorney, Mr. Rossi, responded to a bench request regarding the email address to which EPE sends its monthly reports?
Yes, I was.
And that, do you agree with him that that nmprc.fieldclause@prc.nm.gov email address goes to you?
It goes to me as well as Gabriella Dashno, yes.
Through that email address, do you receive the, it seems kind of generic, do you receive fuel cost statements for any other utility or just EPE?
It's, no, not just EPE. We receive, I can't say all co-ops and utilities because I don't believe some of them send them to that email, but probably a good majority of co-ops and IOUs send their fuel clause reports to that email.
Would that include P&M?
I couldn't tell you off the top of my head.
Do you get an email address? Do you get an email each month from P&M on its fuel clause?
I couldn't tell you.
And how about SPS?
I believe I did see SPS fuel clause emails in there.
And you don't remember whether you can, even though it's due, okay. So when you receive EPE's monthly statement factor, does EPE separately or in connection with that send you the monthly data in electronic format?
They do not.
Do you review the calculations when EPE sends you their monthly FPPCAC?
We do, as far as I know, in the recent history, we have not reviewed them diligently every month, and I concede and I appreciate Mr. Provencio's constructive criticism that he offered for staff, and we are looking to fix these oversights, and we will be working diligently to implement practices that would allow for efficient and seamless review of the 550 reports and the critical components that are reported within it.
How well, that leads to kind of two questions. First of all, how long have you been on the receiving end of these statements from EPE? I'm just trying to get a kind of a back date.
I couldn't tell you exactly. I would say maybe a year or so.
So not
yes.
all of the period for which you've been working for the commission. It's somewhere in between, in the middle.
Yeah, and that's a rough estimation. Yes.
Okay. And you indicated that after reading Mr. Provencio's testimony, things are going to be changed. Has that begun to occur yet, or is this a future plan?
we are discussing, what needs to be tracked, what
Pardon
would
me.
need to be tracked in order to what the key metrics would be. And also, I believe there's been some discussion on hiring a compliance, bringing on a new staff member that would handle compliance items. So we would likely incorporate them into that process as well. So yes, we are definitely working hard to fix that oversight that staff may have made.
Would you go to the Dropbox and refer to CLC Exhibit 3? I think I should have that on my screen. That's just a copy of Rule 550, if you can get it. You see it?
Yes, I have it open.
Okay. So, are you acknowledging that the commission and your section of staff have not been in compliance with Rule 17.9.550.13 over the period at least that you've been involved in EPE fuel clause filings?
Can you point me to the subsection?
Well, first of all, A says that the utility shall file its data with the Records Bureau.
What section are you in, Ms. Stevens?
13, I thought you heard that. Okay. Well, let's go through this quickly. So this section A of 13, second sentence, the monthly data shall be submitted in electronic format to the director of the utility division or his designee on the earliest possible date. Do you consider yourself, by being on that mailing list, the NM fuel clause, do you consider yourself and Ms. Dacheneau to be the utility division director's designee for this task?
I would say so, yes, but also the entirety of the accounting bureau does and can work on fuel clauses.
Right. Okay. And then go down to C. And this is the first sentence. Upon the utility division's receipt of the factor, a review of the calculations will be conducted by utility division staff to ensure compliance with this rule. I think that's the provision that I'm asking whether you are conceding that staff is not in compliance with presently.
I can't speak for all of staff, as the reports are available on eDocket for everyone, in the same format that we receive them in the email. I could speak for myself. I have not, and this is, a process oversight, and we are working diligently to correct it.
So when this case was first filed, when this case, and you don't disagree with the information that's in your discovery response that was included in Mr. Provencio's testimony, do you? At least as of the time it was received. And we can go to it. Just
Let him answer the first question, Ms. Stevens. You can't ask him 3 questions at a time. Okay? Mr. Malden?
Can you direct me to the exhibit,
Sure.
please?
Would you like to see that as an individual exhibit, or go back to his testimony?
Individual exhibit is fine.
Okay, that would be CLC exhibit 38, pardon me.
Where?
1-1. There we go. Thank you. So in this discovery response, Mr. Malden, you were speaking on behalf of staff generally, right? Because that's your role when you're assigned a discovery question?
I don't necessarily know. I mean, if I'm speaking for staff or myself, I could clarify what I meant by these answers if that's okay with you.
Well, let's go for the first point there. When you're given discovery questions that are directed to staff and you're the person who's asked to answer them, do you understand what do you understand your responsibilities to be in terms of completeness and answering on behalf of all of staff as opposed to just your own personal knowledge?
My understanding is that I should answer it to the best of my knowledge and tell the truth, and that's what I did here.
Does the best of your knowledge include checking with the rest of staff to make sure that this is just not your own, what's in your own mind and brain, as opposed to, since the question was directed to staff?
Yeah, there was definitely discussions, and we, obviously, the 550 reports have been reviewed in the past, and they may have fallen off of staff's purview. I can't speak for everyone, but like I said, we are working to fix that oversight.
So, Mr. Malden, in your response here at item A, when you say staff does not review, are you saying Jonah Malden, member of staff, does not review? Or are you saying staff of the PRC does not review?
I think I should kind of clarify that. I think I could have worded this like a little bit better, because it kind of implies that like we never review the 550 reports, which isn't the case. And I would say, I really don't know if Gabriella Deschanel does receive the emails and review the calculations. I mean, it's very possible that she can. It's just not very consistent, at least not monthly as the rule prescribes. So that's where our oversight comes in, and that's what we're going to correct.
Okay, you need to answer my question, sir. I ask you in your response where you said staff does not review, were you saying Jonah Malden, member of staff, does not review? Or were you saying staff of the PRC does not review?
I would probably be talking about myself. Because I did
Okay,
not consult with like the whole bureau to ask if anyone's like reviewing. It was more of a discussion between like a smaller team.
all right, sir. Go ahead, Ms. Stevens.
To follow up on that, Mr. Malden, when you said a discussion with a smaller team for these particular answers, and these are obviously in the context of Epe'S Fppcac, not the others that you get from co-ops and everything. Does this reflect?
Excuse me, I didn't understand that sideline. What did you say?
That this does not, this relates to EPE, not the numerous fuel clause statements that may come into his desk from co-ops and such. So
Is that a question?
I'm getting to the question.
Oh, sorry.
Is in light of these answers, the specific answers, you were testifying about EPE, not other filings. But you also said that there's a small team. When you answered this, did you have Ms. Deschanel's, did you know that Ms. Deschanel also doesn't review these on a regular basis?
That's been asked and answered.
I don't think so.
He responded to your earlier question that he does not know whether Gabriella Deschanel looked at the
I believe it
FPV.
has been asked and answered.
Okay. All righty. Do you believe that the city and other interveners and the company should be able to rely on the staff's answers to interrogatories as being true and accurate?
Objection. That's argumentative. It's placing on Mr. Malden the duty of of utilities to rely?
Miss Stevens?
I'm trying to figure out what staff's roles and responsibility are in this case. And it's not just about this particular answer, obviously, this permeates this case, but I think it's fair because I will get to other questions about really what is staff's duty in any case.
Okay.
And
I-
yeah.
I don't think the question actually, that you fully formed your question before there was an objection. So I'm going to overrule the objection and ask the question again.
I'll try to make it simpler. Now I've lost track myself. So do you believe that this is the question? Do you believe that it's that staff should do its best to accurately answer interrogatories directed to staff as with information reflective of what all of staff does? I know it's a different question, but
Mr. Malden?
I could answer the first part of that question, and I will definitely say that yes, I do believe that it is staff's duty to provide the best answers we possibly can. Yes.
and do you think that the answers you've given in this set are meet that standard?
There's always room for improvement, I would say.
Okay. So your answer does state that you look at continuation filings, and that staff does look at continuation filings. When this filing
Is that a question?
No, it's a when EPE's first original continuation filing was made in this case last February of 2023, did you individually, personally review it about the time it came in?
That was a while ago, but I do believe I reviewed the original application, yes.
And did you do that before or after the commission ordered staff to file a response?
I wouldn't say the for sure answer that a lot has gone on since then, but I believe I did review the application prior to that response, yes.
And your response, which you describe in your direct testimony, describes that response, and you prepared an affidavit for that response, correct?
That is correct, yes.
An affirmation in lieu of affidavit, pardon me. And do you recall that you are the only, that's the sum total of the response to the commission's questions were provided by yourself?
I'm sorry, can you repeat that question, please?
Yeah, were you the only witness who provided, or the only staff member who provided part of the response to that request from the commission to evaluate EPE's filing?
Yes, so I drafted the whole affidavit.
And one of the observations that you made in that affirmation was that the company was at $15.1 million over collected position, right?
Yes, it was.
Was that based on your looking at an individual FPPCAC monthly filing by the company?
Yeah, I believe so, yes.
And do you recall, I mean, I know this is hard because it was more than a year ago. Do you recall that whether it was whether you went into eDocket to find one, or whether you had the NMPRC fuel clause email still in your records?
I probably would have gone into eDocket because to me it's a bit easier to find them than searching through all the emails to find the same filing.
That sounds right. And the phrase that you used in terms of as you say on page 6, line 4 of your direct testimony, you had that $15.1 million over collected status led you to question the efficacy of the current mechanism. Is that right?
Can you direct me to the page and line number, please?
It's page 6, line 4 of your testimony of, I think. Oh, Madam Hearing Examiner is in the pleading, and I'm back to your testimony, which just summarizes this pleading.
I have it up here.
Okay, got it. Efficacy was the word you used.
Yes, it was.
And what do you mean by efficacy as a person and as an economist? What do you mean by efficacy?
Really, I wanted to look into the 12-month average to see if it was doing what it accomplished pursuant to the 20-00104 UT rate case.
So you weren't using some economic technical terminology. You just mean effective.
I just wanted to see if it, was effective, basically, yes.
And are you the only staff member who's been responsible for developing staff's position throughout this case, which has dragged on for quite a while?
Yes.
Okay. Did you participate in all of the informal workshops last summer?
I believe I was unable to attend one meeting.
Did somebody go in your stead and brief you? Your
Yes.
attorney, or I'm not going to ask you what they had briefed you on, but another staff member or one of your attorneys?
Yeah, if I remember correctly, there was 2 economists from the accounting bureau that were attending, and I believe my colleague attended that one.
During that phase last summer, when the case was in sort of abeyance for informal discovery, did staff conduct any research or analysis of its own concerning Epe'S Fppcac application?
Yeah, I believe we did, yes.
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 And is that reflected in the documents attached to your direct testimony, or was that more preliminary?
What documents are you referring to?
Your exhibits.
My exhibits. I mean, those were prepared probably after this case was had come out of the abeyance period.
More likely after the amended application was filed?
Yes, yes.
Okay. So when you were working on your testimony, or after the amended application was filed and a schedule was set, did you read the PRC orders that were relevant to this case?
Gonna have to object that what orders?
Well,
Ms. Stevens, be more specific, please.
Mr. Malden already alluded to the rate case order and the rolling 12-month methodology. So I guess I'll ask you, start off, did you go back to case 20-00104 UT?
Yes, I believe I skimmed through the RD to try and find the language for the 12-month average, as well as maybe I believe I looked briefly at Adrian Hernandez's testimony on behalf of EPE.
Oh, you went digging into you went digging into eDocket to find the testimony? Good for you.
Yeah.
So, let me look a little bit off from that line here. Could you look at your own testimony in this case on page 13, lines 1 through 11?
Okay, I'm there.
Yeah, okay. And the question you asked yourself, or somebody asked you, First is, does EPE's filing make the same showings required of initial tariff filing set out in 17.9.550.16 NMAC? And you say that, oh, and then in the second paragraph, you talk about Mr. Schiestel's testimony about the percentage of things. Do you believe that this is an allusion to not just 15.50.16, but also the objectives of the rule in 17.9.550.6?
Can you explain by what you mean by
Yeah, I'm looking
illusion?
for where you talk at where, if any, where you talk about, let me find, maybe if I do my own version, maybe I can do a quicker word search. Okay, yeah, let me approach this slightly differently and try to get some. I'm now at page 8 of your testimony. And on the first, the upper part of page 8, you talk about the section 6 of Rule 550, the various objectives, so broader objectives. You understand that a compliance filing needs to show that those objectives are being met also, right?
Yes, I do.
Okay. And is there anywhere in your testimony where you address the question of whether the EPE's FPPCAC satisfies the subparagraph B of 550, provide for the stability of utility earnings when electric fuel costs and purchase power costs are rising, and permit prompt credits to customers when electric fuel costs and purchase power costs are declining? Do you address that in your testimony?
Objection. Section 6D doesn't say that.
B. Maybe is my audio bad? I said B.
Mr. Black, she's saying section B.
B as in
B.
boy. B as in,
Okay, thank you.
and honestly, if I'm hearing myself, not the computer audio. So if there's a problem, let me know.
Mr. Malden?
So you asked if there's a section of my testimony that addressed section B.
And section where? Which
Uh,
page?
Oh, I was just rephrasing the question to make sure I got it.
Oh, the question. Yeah. No, okay. So the question is there, yeah. And do you have an answer to that question? Where in your testimony do you address that?
I'm not sure I address it directly right off the top of my head. But I think it is demonstrated, especially in the chart that I provided as part of CLC response, or my response to CLC 2.
Well, let's go to that. You know, because of already sparring with Mr. Black, that would be the cities. Did you say 2 or 3 or 2 or 1?
I believe it's 2. Let me see
Okay.
if it is attached. It looked like it was attached. I suppose,
Yeah, I think well, I have it. Would you look at I think I have what you're talking about. Would you look at CLC Exhibit 49, please?
Mr. Malden?
Are you with
Uh,
me?
yes.
Is this the response you're talking about a chart?
Yeah, so there's a CLC 2.4 attachment 02, page 505.
Okay, good. I was going to take you there myself. So you recognize this as your discovery response to the city, right?
Yes, I do.
And this discovery response covers the period from January 2017 through February 2024, right?
Yes.
And I think before we got into the exhibit, you were answering the question about why you believe that why, even though you didn't directly address it, the fuel clause demonstrates that it results in prompt refunds to customers when costs are declining. Is that right?
Yes. So, I
And
mean,
looking at this, well, first of
Let him
all,
finish his answer. I don't think he was finished, Miss Stevens.
sorry.
so
Mr.
this chart,
Malden?
yes. So this chart, I mean, I look at it and, you know, I know the December off sales, the unexpectedly high off system sales caused an over recovery, which wasn't necessarily the factor's fault as far as not refunding that, as well as it caused for a over recovery, right? Which is I guess the dot that's about halfway up that very large, you know, rising peak there. And then the
What,
billing error. Oh,
am I looking at the same thing here? I'm looking at your chart, page 2
uh,
of 5, CLC 2.
page 505, sorry.
Oh,
There we go.
okay.
Thank you.
Yeah, okay. You meant this, not the list, not the table.
Yes, yes, sorry about that. Yes.
Okay.
Um, let's see. I guess I could restart. So December 2022, the over collection that was a result of the abnormally high off system sales. That caused inadvertently a over recovery because the volatility I mean the factor and EP couldn't predict that they would sell so much power that month. I think they almost generated $7 million in margin sharing with customers. So that caused the over collection to dramatically rise to 10 million. And then after that, the billing error, which was no fault of the fuel clause, it was a billing error, caused it to then rise again to 15 million. And then as you can see, the following 6 or 5 months, so March, April, May, June, all of those months had a credit for customers, and it effectively refunded this abnormal situation that resulted in an abnormally high over collection within 5 months. I do think that that is reasonable to refund such a large over collection that was a culmination of very unlikely events.
Well, let me ask a few questions about that. First, I think I heard you say something about the 15 million was the result of the um billing error. Did you just say that, Mr.
Um, you might have,
Walden?
I could have explained that better. And the whole 15 million wasn't a result of the billing error. It was the jump from 10 million to the 15 million.
Could I ask you to look at your table that precedes the graph there?
Yeah, I'm there.
Okay. And isn't it true that the 15 million over collection was reported as of the end of January, before the February billing error occurred?
Yes, you're right. That's my mistake. So yes, the January overbilling was a result of December's off-system sales being very high and not taken into account by the factor. And then, February, the customers were overbilled, and thus it delayed the customers' benefits from those off-system sales.
Can you explain to me why, if they were, you agree that customers were overbilled by effectively $8.3 million in the month of
I'm
February?
sorry, Miss Stevens, we're overbilled by effectively, and you're coming through muddled, at least on my end.
Oh, it's my notes again. I'm sorry, they crossed over. So would you agree that in February 23, customers were effectively overbilled by $8.3 million?
I generally agree with that, but I kind of look at it as like if there was a line, a horizontal line, and that's zero, EPE should have refunded them, which would have been negative, right? And then they made the mistake and they overcharged, so that put them in the positive. So they're kind of equidistant from zero. So that over collection was what was collected in that month via the factor. I believe it was like 4 million. But in essence, yes, I would agree generally that the total over collection was 8 million, just because they were overcharged 4 million when they should have been credited around 4 million.
Simple. So can you explain to me then why this chart, your chart, your table, I will call it chart, table here, how it could be that if customers were overcharged by over 8 million in February, how come the cumulative overcharge went down on this chart from 15 million to 13 million instead of up?
I think you lost me on the last part of your question.
If you could go, Madam Harris, if you could go up 2 pages, I think it is. Yeah. Thank you. So, no, it's one more down. I guess it's one more up. No, that's the right one. I'm just mixing up my black and white. Okay, so can you explain why or how it could be, under the operation of the fuel close mechanism, that the company was reporting a cumulative over collection in January of $15 million, and then it actually then it actually overbilled by 8.3 million in February, but still shows a lesser $13.25 million cumulative over recovery for, which I think is the end of February.
So you're asking why it increased from
Why it
January
decreased, actually.
decreased? Okay. Well, can we look at the billing, the 550 forms for those months?
Yeah, yes, I think they're already in evidence from well, actually, they're already in evidence, as I think I don't have one of them, but we've already got CLC 24, start 24 February 4, 20.
What page do you want to see, Mr. Molden?
Yeah, pick
It
your month and your
probably,
page.
I guess we could pick February, work paper.
You want
A.
February?
Yeah, that works.
Any particular page?
Probably work paper A, page 1 of 4.
Okay, there you go. You're at 2 minutes, Miss Stevens.
Okay.
Okay, I kind of got mixed up there, but so the over collection decreased. I don't believe you have January in
I'm afraid
your
I don't.
so I because they operate on a 2-month lag, so the December billing mistake didn't go into effect until February, and January was billed because of November. So I kind of can't really
I think you might get some indication if we go down one page or up one page and do those cumulatives, those monthly, the prior month, second preceding month business. Does that help you or not?
yes, I mean yeah, so I mean the second month preceding the current month they were under collected by 7.5 million. Current month recovery 5.733 million. And the cumulative over under for the prior month was 15 million. So then all of those netted together, this negative 7.5 million is about 2 million more than the 13 million. So
And since my time is about to run out, Mr. Malden, can I ask you why you didn't include in your analysis, in your direct testimony? And I'm back to CLC Exhibit 49, the response to CLC 24. Why you didn't include the information for January 23 through February 24 that you provided in the discovery response?
that's because it was my personal understanding that the parties had agreed to include up to 2022 and that EP had agreed to include up to that to provide more data for the 12-month rolling average. And so, I mean, there's, what is that, 6 years from 2017 to 2022. I mean, I thought that that was sufficient. And I mean, if we were to keep looking forward every month that the case goes on, we can include another month. So it's kind of like an analysis call to kind of set the line somewhere. And plus, I thought the parties agreed to that time frame.
Ms. Stevens, that's your time has expired.
Okay, thank you, Mr. Malden. I'll move. I don't know whether I should move to admit CLC 49 since it's already part of Mr. Provencio's exhibits. I'm not inclined to do so, but if somebody wishes to have it, here's your access. Okay, thank you.
Okay, let's go off the record for just a second. We need to make a scheduling call at this point. It is approximately 20 after 12. Ms. Souls, you've reserved 20 minutes. Are you going to utilize those 20 minutes?
Yes, ma'am, I believe so.
Okay, and I've got some questions. So I think potentially we've probably got another 45 minutes of questions for Mr. Malden. Do we want to take a lunch break for an hour and then come back? Or do we want to proceed on? Mr. Lee, what's good for you, sir?
I am at the pleasure of the court. Whatever the parties wish to do is fine with me.
Okay, well, you're the one who's top consideration in my book, sir. Because you're the one that's actually doing the physical mental interaction here. Does anybody have a preference?
Madam
Ms.
Hearing
Souls?
Examiner, I can certainly carry on, but I do need a short personal break.
Okay. Is there anybody that wants to break for lunch and not finish up probably before 1? No. Okay. Let's take a 5-minute convenience break then. and we'll come back at 12:25 and continue on with questions for Mr. Malden. Remember the YouTube.
Good idea. What?
Okay, I think we can go back on the record. And Ms. Souls, you reserved 20 minutes for questions for Mr. Malden. Please go ahead.
Thank you. Hello, Mr. Malden. My name is Mary Lee Souls. I'm a pro se party in this case. And I'm looking at page 1 of your testimony, your credentials. It's quite an impressive background. In your business management courses, did you take a course in cost accounting?
Cost accounting. I'm not sure I took one exactly titled cost accounting, but as you can see on line 18, I did take the public utility accounting course.
Very well. Have you taken courses in sales or pricing?
No, I wouldn't say so. Well, unless you count economics in college, then I took
Okay.
2 econ courses.
Did any of your regulatory training courses address costing of off-system sales?
I don't believe so.
Are you familiar with Epe'S costing models?
Generally, and mostly from the testimony filed in this case.
Did you participate in the informational workshops which Epe held in this case?
All but one.
Did you participate in the workshop dedicated to the topic of the costing models?
I'm not positive which one I was unable to attend. Yeah. I couldn't answer that. I'm sorry.
Have you gone into any of the costing models on your own?
I've browsed what's been provided through Discovery. I could say that I haven't gone too deep into them.
You have been in those confidential costing models?
Were they differentiated in the shared drive as a non-confidential and a confidential?
In El Paso Electric's response to Discovery, are you asking were they in the confidential folder there?
Yeah, I believe, I mean, I'm not sure. I think I looked at the confidential costing model. It was very brief.
Would you claim to understand the costing models?
I wouldn't claim to have an in-depth understanding of them, no.
Okay. Go to page 9, please, at line 12. You're identifying the requirements of section 16 of Rule 550, is that right?
Yes, ma'am.
And would you agree that the utility is required to submit testimony showing that all of the objectives stated in 17.9.550.6 are met?
That's what it says, yes.
And would you agree that one of those objectives is the utility's fuel and purchase power policies and practices are designed to assure that electric power is generated and purchased at the lowest reasonable cost?
Yes, I see that.
So you would agree that is one of those objectives?
Yes.
At page 10, at line 7, where you're asked, does Epe'S filing address the considerations described in paragraphs 1 through 4 of subsection E of 62-8-7 NMSA 1978? You respond yes. Is that your testimony?
Yes, it is.
So I want to ask you a different question. Did Epe show that Epe's fuel and purchase power policies and practices are designed to assure that electric power is generated and purchased at the lowest reasonable cost.
From the evidence presented in the case, I mean, I believe so. You know, I will say that, you know, I'm not an expert in dispatching power, operating grids. What I did do was go through all of the Excel files that EPE provided, which was the 550 monthly and annual reports that were provided in Discovery from 2017 to 2022. I checked all the calculations. I did not see anything that would lead me to believe that EPE is not following this requirement.
Can you identify the specific policies and practices that El Paso Electric offered in their showing?
Other than what's listed in my testimony, which refers to EPE's evidence presented and my analyses, I mean, that's what I thought was necessary to reasonably determine that they are adhering to this requirement.
So here on page 10 at line 9, where you're responding to the question, at line 9 you say Mr. Schiestel addresses. Do you agree?
Yes.
At line 11 you claim he asserts. Do you agree with that also?
What line was that? Sorry. Oh,
Line
yes,
11.
I see it. Yes, I agree.
So is there someplace in your testimony that establishes that you, Jonah Malden, come to this conclusion?
Sure. Let me see what page it is. If you scroll to page 17, table JVM1.
Okay.
So, really, what I wanted to do with my testimony was work through the requirements of the rule, evaluate the evidence EPE presented, and then design my own analyses that would verify those statements. Because I think kind of a general motto is to trust but verify. So what I tried to do was verify what they said. So in one of those,
Are we waiting for something?
Pardon me?
Can you folks hear me, Ms. Olson?
Yes.
Thank you.
I can hear you, Mr. Lee. I seem to have lost the link to the real time, but. So, Mr. Malden, we're looking at your table.
yes, ma'am, JBM1.
Where do you define what the A, at the bottom?
Yes, ma'am.
No, where do you define where the A and B are? What they are?
Ooh. I think you're right that probably the A and B shouldn't be to the right of the table. I think those are essentially going to be the formula I used for the average. So B minus the absolute value of B minus A divided by A.
But A is the minus 427,888.
I believe that those are mislabeled because I'm not. Oh, okay. So those output the percent increase in customer credit, the 116%, which has the little one to denote like the footnote.
So then A is 90% and B is 100% in your table?
A would be the 427,888. So those were labeled correctly. That was my mistake. And then the B is the 927,128.
Okay, go ahead, Ms. Souls.
So I appreciate this, but is this a practice or policy related to the generation purchasing of power?
This is looking at the outcome. So,
Alright.
I mean, ideally, if they are responsibly managing their operations, you'd expect, especially with the 90 to 100% increase, you'd expect the amount of margin that is being shared with customers to increase. And in this case, it did by 116%.
And so you're referring to the accounting change that they were directed to make. Is that correct?
Not only that, because it increased by far more than 10%. So this demonstrates not only that I believe that they are in fact sharing all of the margins with customers, but they seem to be doing a better job at creating more revenue and more margins for customers.
If this is margin sharing, how is that related to revenue?
The margin would be the profit made off of revenue and power sold.
Would you agree with me that you could reduce cost and that would also do it without doing anything to revenue?
Yeah, I think I would agree, yes.
And are you aware that Ms. Soul's testimony and entire dynamic in this case is related to the manipulation of that costing?
I think, yes. I mean, yeah, I got that general idea.
All right. Are there any other specific policies and practices that you relied on to conclude that EPE had satisfied the requirement we were talking about previously?
I don't think so. Though I did find the rebuttal testimony of like Victor Martinez to be helpful in more understanding how they operate and that sort of thing. And I believe I briefly looked at their policies as well, which I'm not sure whose testimony it was attached to, but it was a rebuttal testimony by an EPE witness.
And did you do any other independent verification of the claims El Paso Electric made?
No, no.
Very well. Are you familiar with the costs of El Paso Electric's different types of generation?
Generally, I believe I saw a table in Victor Martinez's rebuttal. Yes.
And so what do you understand about the relative costs of, say, nuclear power versus local gas generation?
I couldn't tell you off the top of my head. I believe it ended up somewhere in the middle of the generation, if I'm not mistaken.
All right. Thank you, Mr. Malden. I have no further questions.
Thank you, Ms. Souls. Good afternoon, Mr. Molden. I've just got a few questions for you. And first, I just wanted to make sure that my understanding of your testimony was correct. And The the questions that Miss Stevens was asking with regard to the interrogatory response that had the graph on it. Do you recall those questions?
Yes, ma'am.
Miss Stevens, can you tell me what CLC exhibit had that?
I believe it's 49.
Okay, guys, just looking at 48.
49.
Yeah, very good. Okay, yeah, there we are. Based on the question she asked you and what I interpreted to be the considering the events prior to the billing error, do you believe your chart is correct, or do you think you made a mistake?
Um, I'm not positive. Let me double check. I do know it's kind of hard to see what point lines up with what month, so I was actually having trouble with that myself.
And the reason I asked that is because I think what she was pointing out to you in her questions was the fact that there were things going on regarding an over recovery prior to the billing error, right?
Yes, ma'am.
So it was unclear to me in your explanation if you still stand by your chart here, or no.
Believe I do.
Okay.
I might have got my months a little shifted there. But I believe so. In December there was 10 million over recovery, and then January, I'm not quite sure since I don't have it up, but I do know that February was the 13 million, so it's kind of starting to go down, which is because it has the offset from the uh from the second preceding month, so November or
Okay, and I'm not trying to cause you to doubt yourself, Mr. Molden. I'm just trying to clarify in my mind the result of the questions.
Yeah, I mean, if I may, even if the chart may be shifted, I could kind of like explain like kind of my understanding of the over recovery and like the 10 million, and then it shooting up from 10 to 15 and then coming back down.
Go ahead, sir.
So
Miss
I know
Olson, if you can hear me, I'm going to step away, but I'll be within earshot once everybody comes back on.
Hey, hang on.
Did you just nod your head? Did you hear me?
Mr. Leak, can you hear me? is there anybody besides me that think we have a problem?
I think we have a problem. Could he
I'm
be on,
not sure why he's talking to me.
could he be on a different Zoom, like back some hour, back at 40 minutes from us, 20 minutes from us?
Well, let's go on a recess till I figure out what's going on. I have 12:45.
That's weird.
Remember, we're still on the YouTube.
Hello.
Hi, Mr. Lee, can you hear us?
Hello.
Mr. Lee? Can you hear us?
Can you not hear me?
Can you hear us, Mr. Lee? Oh, isn't technology grand? Hey, Mr. Lee, can you hear us?
Hello?
Hi, can you hear us?
Can anybody hear me?
Yes. Can you hear us?
Miss Stevens, can you hear me?
You're muted, Miss Stevens.
I can hear you. Can you hear me is the question. Mr. Lee? No? I don't think he can hear us. David, Jonah, Madam Hearing Center, we can all hear one another.
All right, I can hear you. Can you hear me?
Yes.
Yes, now.
Apologize.
Yeah, we went back on the record. We thought
You were
you were there because we only took a 5-minute break.
Oh, I have been here and I could see everybody and I was waiting. All
you
right,
you didn't see the mouths moving?
I did, but I didn't know if people were having discussions.
Oh dear.
Okay, well, I guess what we're gonna have to try to do, I guess you probably can't pick up the examination from the YouTube, or can you?
If it was sent to me, I could.
Okay, I don't know how to do that. You'd have to go on the YouTube link, I guess, and do it. So I guess our only other alternative, Miss Souls, is to try to recreate the questions that you have for Mr. Malden. Since that's the part of our transcript that we lost. Right?
I can certainly try.
Okay, well, let's try this again with our court reporter.
Madam
We're
Hearing
back.
Examiner,
Mr. Rossi.
I'm so sorry to interrupt, but I was able to pull up the YouTube and it does look like it recorded that section. I can send him that link if that works for you, but it's a little bit, he may want to check to make sure it plays before we move on.
What do you want to do, Mr. Lee? Do you want the YouTube part sent to you? Oh, we just lost your video. Oh, there you go. Do you got an unstable link?
Connection. I don't know why.
I can't hear you. You're pixelating. I think you're losing your connection. We can either try to recreate or you could possibly get it from the YouTube.
I can get it from the YouTube. Can you hear me now?
Yeah. Mr. Rossi's going to send you that clip. Do you have his email address, Mr. Rossi? Let's stay off the record till we get this figured out.
It is a little confusing when you accidentally open the YouTube of right where we just were. And you hear everything 10 seconds delayed.
And scary.
Well,
yeah.
Happens to me all the time with the open meetings. I never know where I am.
So do you need his address, Mr. Rossi? Or do you have Mr. Lee's email?
Yeah, it does not look like I have.
Mr. Rossi.
Mr. Rossi just froze.
I do not have Mr. Lee.
Mr. Rossi, it's Cumbre Court, CUMBRECOURT @Comcast.net. Can you hear me?
Did you get that, Mr. Rossi?
He's frozen.
Comcast.net.
Oh,
Did you get it sent?
Yes, it did.
Thank you. So, Mr. Lee, you can just let us know when you get it and if it opens.
I've done it before, Judge.
Oh, okay. So you think we're good to go then?
Yes, Judge.
Okay, very well. Okay, so we're back on our record. And is there going to be any objection to the fact that we're going to include the Ms. Souls cross-examination of Mr. Malden from the YouTube tape? Okay, there's no objection. So if that works for Mr. Lee, then that works for me. And I'll go back to my questions. So you'll pick up part of that, Mr. Lee, until we found out that you are not live with us. And you were giving me an explanation, I believe, Mr. Malden, of your graph in response to CLC, I guess 2-4.
Yes, ma'am.
And as best you can, anything else you want to tell me about this particular graph and the circumstances for that particular time period?
Yes, so I was able to just double check on my paper copy and label all the months and points on the graph. So they are correct. The $15 million over collection happened in January. And that was because of the over collection that happened in December and the adjustment that happened that resulted from that. So which the adjustment from December caused February to decrease a little bit from 15 million to 13 million. But that is also the month where the billing factor was billed incorrectly. So from there, then it starts to decrease, which is why in the table above on page 2 of 5, I believe. Yeah, page 2 of 5, it's 15 in February. It's 13 because of the adjustment that came from December 22's over collection. So then it kind of starts to decrease, although it was incorrectly billed. And then by April, we start to see it. Well, all the next preceding months, those are all credits until June 2023 on customers' bills. I think it's probably also worth noting that these two scenarios are incredibly unlikely. So I looked through the data from 2017 to 2022, and there was not a time in that data where the net purchase power was negative like it was in December 2022. So that was uncommon based on the historical data. And then, of course, the billing error is uncommon. I would say, I mean, it hadn't happened in the 6-year period. So I think we could call that uncommon and probably less likely to happen going forward. So I wouldn't say that these are, this overcollection is very high, but I wouldn't say it's necessarily a failing of the FPPCAC mechanism. It was more so like a culmination of two unlikely events.
Okay. Sir, if you could look at your testimony, my copy, it's page 7, and you're answering the question posed at line 9. Does staff have any additional notes relating to this case? Interesting phrasing. And I'd like to look at your reference in that answer to case number 20-00175 UT. Can you tell me what that case is?
This is, are you looking at the footnote on page 7 or?
No. I'm looking at your reference on line 11.
Oh, okay. Yes. I believe that was the rulemaking that changed Rule 570, which prompted EP to file the advice notice to change their QF rate 16.
And do you believe that case has any potential impact on this case?
Other than just reporting the power that they purchase from the qualifying facilities, I don't think it will have an impact, as they essentially changed that rate just to become compliant with the new rule, and it's not and this is, I mean, it's changing the rate, but I wouldn't expect it to have any kind of large impact on this case at all. Like, I think most of the QF customers are probably rooftop solar customers.
Do the case number in the footnote 23-00222, that's still pending?
I believe a final order was issued in probably the second to last open meeting.
So you think there is a final order in that case?
I believe so, yes.
Did you read it?
I haven't read it, but I did watch the open meeting when they discussed it.
And did that case have any impact on this one?
Other than I think EP agreed to report the QF purchases on the 550 report. So I mean, other than that, that would probably be the most notable change.
Okay. On page 12 of your testimony, you're answering the question posed at line 7. Has EPE included a revenue and expense statement that contains an analysis of costs and reviews included in or affected by the operation of the utilities FPPCAC in compliance with 550.17b? And then you answer that, and then the very last sentence, you say, as a result, EPE is not seeking to reconcile fuel and purchase power costs in the amended application. That's your testimony?
Yes, ma'am.
Do you think they should?
I mean, I would never be necessarily opposed to a reconciliation. I did go and look at the RD, I believe it's the recommended decision from the 20-00104 rate case, the remand RD that allowed them to reconcile. And I believe what it stated the reconciliation is that essentially EPE matched their cost to their purchases. So, I mean, I would never be opposed to that. I think it's, good practice for sure.
Have you reviewed any other FPPCACs for any other utilities?
I've reviewed a few co-ops. I've briefly looked at, I believe SPS and PNM, but it's been a while since I looked at those, and not like a formal hearing or anything of that matter.
So when you say that you looked at the final order on remand, in case number 20-00104 UT, are you referring to the order that the commission issued in that docket on November 30th of 2023?
Let me check my notes. I think I have a citation to where I live. So it was the final order on remand. I don't have the date. Yeah, I mean, I would imagine that it was in that one.
Well, if this is the only order on remand, I think
Yeah,
maybe
okay.
that this is it.
Yeah.
Okay. And basically at item 30 on page 11, it says the commission further adopts staff's recommendation to grant EPE's request for reconciliation of EPE's FPPCAC for the years 2017 through 2019.
Yes. Yeah, that's what I saw. Yes.
Is that what you looked at? Then further on page 12 at item 31, the commission says the commission's approval of EPE's reconciliation simply means that EPE matched its cost recovery to its actual fuel and purchase power expenses, comma, nothing more.
Yes.
Did you read that?
That's what I have in my notes exactly. Yes.
So it appears to me that it's been a past. Do you know of anywhere in Rule 550 or somewhere else where a reconciliation is required?
I'm not sure that it is required. It may be in the rule. Actually, it may not be. Yeah, I don't think it is in the rule actually. Though I don't know. There may be a rule that is related to reconciliations in general.
Do you know what that is?
Not off the top of my head. No.
Mr. Black, consider it a bench request.
Understood.
Thank you.
Madam Hearing Examiner? Anastasia Stevens.
Yes, ma'am.
I'm not sure where this is going, but I do have concerns that you may be reopening the issue of reconciliation, which EPE didn't ask for, and doing it on the basis of evidence that's going to come in after the hearing. This is troubling. Again, I don't know where this is heading. I'm just saying my antennas say this is troubling.
Well, I don't know if that's a objection to my
I don't
bench
think I can object
request.
to your bench. I don't know whether I can object to your bench request.
But here's the
If I
thing.
may, I will.
Well, let's put it this way, Ms. Stevens. There was an initial request for reconciliation, and then the request appears to have been withdrawn in the amended application in this case. There's testimony on reconciliation in this case. And there's been a representation by El Paso Electric witness, I believe Reza, that there is no requirement. And I want to know from staff what their opinion is. So the witness doesn't know on the stand, so it's a bench request.
Okay.
So if in fact, do you know, Mr. Malden, whether or not it's been a past pattern and practice of the commission to consider reconciliation in its FPPCAC proceedings?
I do know it was a part of the 180006, I believe, the last EPE continuation. I believe they reconciled 2 years in that case. It might have been 2016, 2017. But outside of that, you know, I know that there is reconciliation in maybe other riders, but with the context to FPPCACs, I mean, that's really the only one that I'm aware of. And then the 2020 rate case.
Okay.
Madam Hearing Examiner, I apologize. I just got kicked off the Zoom and back on. And I did not hear Mr. Malden's response to your question about whether or not the commission requires reconciliation as a practice. Could you just repeat that response for me?
My understanding, Ms. Olson, is from Mr. Malden's testimony is he wasn't aware that it was in 550, and he knows that the commission looked at reconciliation for El Paso Electric in 180006, and then again in 20-00104.
Thank you. I apologize
Okay.
for the.
It's okay. Okay.
So to clarify, is the bench request still in necessary or the
Yes.
response? Okay.
Yeah, I want to know whether or not, I want to know staff's opinion of, since Mr. Malden also testified that there are reconciliations in riders and other types of things, that there might be a reconciliation for FPPCAC somewhere outside of 550 was how I interpreted that. So, so yes, sir. Mr. Malden, you read the rebuttal testimony of the witnesses, the El Paso Electric and the intervener witnesses,
Yes, ma'am.
and did the distinction that was being made about the difference between the price versus the cost uh, did that testimony in conclusion give you any pause for your review?
Yeah, definitely. So the way I view it is the cost is generally, the cost that I guess, in this case, it's the cost that EPE incurs to, let's say, purchase gas to produce electricity. And then usually the price is associated with some kind of markup. I believe the technical definition is the price that a customer is willing to pay for a product or service, which implies that there's a markup from cost to generate some profit. And as far as I know, EP is not allowed to do that and does not do that. So to me, in this instance, cost and price can be used interchangeably. But I mean, I believe, yeah, that in this instance, they're equal because there is no markup on it, any of the costs flowing through the FPPCAC. And kind of a related note is kind of like the average, because I know that's kind of what this was tied to, the 12-month average of the price per unit versus the summation of consumption and the summation of the cost. I think both methods have their merits. I think both technically could be correct. I think it's when looking at the final order that approved the 12-month rolling average, I'm not a lawyer, but I mean, the cost, the actual cost, I mean, I don't think that dividing the cost by consumption by every month turns that figure, the dollar per kilowatt hour, into a price. So I do believe that taking the average of the cost per kilowatt hour for every month is valid as far as the final order, as well as I think in this instance it may be the superior methodology, just because it puts less, I shouldn't use weight, it skews the average less for consumption. So if there's a month with, well, actually, I mean, could I have you look at one of the DAC exhibits? I believe
Sure.
it has a table.
Which one would you like?
DAC 3, page 2 of 6. And then the table there on page 2 of 6. Yeah, that one. So with this table, I mean, I was basically trying to show that there is a difference between the two calculation methods. But if you look at the consumption, for all but 2 months, the consumption is lower than the cost. And I just made these numbers up kind of arbitrarily and made them small so that it was kind of more readable. So the consumption is lower than the cost for all but 2 months, which are months 11 and 12. In those months, cost is equal to consumption. And then if we look at the cost per unit, the cost per kilowatt hour, 8 of them are within the range 1.4 to 2. So the majority are around or above 1.5. And then we have 4 months 9 through 12 that are within the range 1.33 to 1. So if we scroll down a little bit to the top of the next page, and we compare the averages that come out through the two different methodologies, the first being you sum the total cost and the total consumption for the 12 months, and then you divide the two, you get 1.17 as the average. To me, I think that's a little bit skewed downward because the consumption is lower in 10 of the 12 months. Whereas if you look at method 2, which takes the average of the 12 months per unit cost, the dollar per kilowatt hour, it comes out to right around 1.5. And the majority of the cost per kilowatt hour for every month were near or above 1.5. So I think in this instance, when we're trying to look at or set the base cost factor for 2 months in the future, where consumption is going to vary in those 2 months, and the month that we are setting the base fuel factor for, it's probably never going to be the same. So I think it's more appropriate to focus on the costs independent of the consumption. So I do think that method 2 here, which is the average of the dollar per kilowatt hour, is more appropriate for this situation.
Okay. Just to switch topics a little bit, on page 19 of your testimony, and I think you began the testimony on page 18. You're referencing the WEIM. Is that correct?
Yes. Oh, yes, yes.
And on page 19, line 15, you say staff believes EPE has adequately addressed how joining the WEIM may impact the Fppcac, and has demonstrated it is a net positive for the company as it provides added capabilities and opportunities to the company. That's your testimony?
Yes, ma'am.
Was this opinion from you based solely on EPE's testimony, or did you do any independent investigation or analysis into the EPE's relationship with the WEIM or the WEIM itself?
Yes. So, I mean, for a large part, it is based on their testimony because I'm not, well, I'm aware of it, and, I kind of have a general understanding of it. I did have to rely on their testimony, but I did also look at WEIM's website, and I believe they report performance reports quarterly, and I do remember looking at one of those probably a while back. I'm not too sure when it was, but and it did show that EP was performing well and receiving benefits. I think it might be a quarterly benefits report that WEIM publishes on their website.
Okay. And then additionally, you're justifying that you did an additional analysis in this case called a Thompson Tau, TAU test.
Yes, ma'am.
Is that correct?
Yes, ma'am.
Who utilizes this this test?
From what I could tell, I believe it's used in finance, I believe engineering, maybe even aerospace. It's kind of like an academic test. But kind of my reasoning for using it in this was, I wanted to check all the bases, make sure that EPE is filed was compliant with in my opinion, with the rule. And then I wanted to come up with some analysis that would kind of let me verify this. And in my kind of research, I found this one. I thought it fit well because all the data that I was looking at is time dependent. They each affect each other. They have temporal dependencies. So I believe the test was a good way to look at the entire data set from 2017 to 2022 and look at the numbers instead of me going through the spreadsheets and trying to identify an overcollection that I think just looks big to me. I wanted to have a mathematical way to define if an overcollection was an outlier. And then for the ones that the test did identify were an outlier, what I wanted to do was, do they have a reasonable explanation? And for the ones that the test identified, I did find a reasonable explanation for them.
Has that test been used before here at the commission?
Not that I'm aware of, no.
Have you used the test before?
No, I actually found it when I was looking for an outlier test to use on time series data, basically.
And final question I have for you, sir, that relates to your recommendation that EPE be required to submit monthly and annual 550 reports in Excel format with all the formula intact.
Yes. Sorry.
Would that include any confidential information?
I don't believe so. I could be wrong, but I believe EP may prepare those forms in Excel already. That's pure speculation on my part, but.
Okay. Why did you request this?
Because, of course, the oversight that was pointed out and point was well taken. So to me, taking data and checking calculations from a spreadsheet is much, much easier than looking at a PDF, trying to recreate it, and then you have no clue what the formulas are. So there's no way to check the calculations. So this recommendation kind of comes from the fact that, yeah, we did have a little bit of a misstep there, but we're going to develop a way to track these metrics from the 550 reports that will be efficient and allow us to track everything more easily. And I think, just getting them in an Excel file just kind of makes it that much easier for us.
Okay. Thank you, Mr. Molden. That's all the questions I have for you. Mr. Black, any redirect for Mr. Molden?
No redirect. You asked the questions that I was thinking about, so thank you.
Thank you, Mr. Black. We'll go back. Ms. Olson, anything for Mr. Molden?
No, Madam Hearing Examiner, I don't have anything. Thank you.
Thank you. Ms. Winter, anything for Mr. Molden?
Nothing, Madam Examiner.
Thank you. Ms. Stevens?
I do. I'm sorry. I'm going to
Go ahead.
I'm going to work backwards, I think, from my margin notes, Mr. Molden, on hearing examiner's questions. So regarding her most recent question about why you requested electronic format, does that relate to the rule that we looked at earlier that says that it should be submitted in electronic format to the utility division director?
I don't believe so. I mean, electronic format could probably refer to a PDF just as well as an Excel file. So I don't think it's in the rule. It's kind of just asking, kind of like, can you help us out? Like,
okay. You testified to me that you do receive filings from other utilities and co-ops. Do those other utility and co-ops interpret the rule by submitting their actual, executable spreadsheets when they mail it to nmprc.fuelclause.gov or whatever it is?
So for every co-op continuation case that I have seen since I've been with the Accounting Bureau is that's one of the recommendations we include. It just makes working with the numbers much easier. So yes, we do ask them to, and sometimes they don't. I mean, but
You say you asked them to do it in a continuation case. I'm just asking, trying to understand whether that request is based on the interpretation of the rule or convenience.
well, like I said, I think it can be interpreted from the rule because electronic format that's a very wide variety of formats. But I would say for both to answer your question.
And how about you say that you get P&M and you've seen P&M as SPS ones? How about the big
Sorry,
guy?
I'm sorry, Miss Stevens, you broke up.
Oh, you've testified that you've seen P&M and SPS monthly filings, right?
Yes, ma'am.
Yeah. So do either of those IOUs provide as part of their package to an NMPRC fuel clause dot whatever at PRC? Do they provide their calculations in a executable spreadsheet?
The ones that I looked at were PDF, and I couldn't tell you if they do submit it via Excel, but I would guess probably not. But
And this is what you get every month on that every month from each of the utilities on the basis of that NMPRC fuel clause address? You don't remember?
You're asking if my answer was that's what we get to the email?
Yeah, I'm trying to get what you get in the email as opposed to what you looked at, because I think you told me, then you're right, that it's easier to find them on eDoc.
Let him answer the question before we go. Is that what you get in the,
So we get the same filing that goes to eDocket for most of these, other than the ones that we've asked to submit Excel files, and they do.
And that does apply to P&M and SPS.
We will, I mean, yeah, as a part of this process to track these by 50s more closely, I would imagine that we will ask them if they would supply those in Excel format.
My question is currently, or within the time that you've been on that list, do you see them electronically, or do you just see the filing, the PDF that's filed with the commission?
I think he's asked and answered that twice already, Miss Stevens. So why don't you move on, please?
Okay, I'm not sure he has, okay. Going back to your analysis of, now I'm gonna have to find it, where Madam Hearing Examiner had up your testimony with the analysis of the the Thompson Tau information and your exhibit on that. I think it's at the end of your direct testimony or near the end of your direct testimony. Direct testimony? Yeah, no. You stopped at December 2022 for this analysis, right?
Correct.
And when you answered the city's discovery response, you provided information that went beyond December 2022. Did you have that information available to you when you did your Thompson Tau analysis?
I did not include beyond December 2022 in my analysis.
Yeah, that wasn't my question. My question was, did you have that information available to you?
No, I never prepared that, but I did already have the up to February 24 of the analysis I provided you.
You had that, you had done that, but you chose not to do the Thompson Tau on the next 14 months. Is that what your testimony is?
Yes.
Okay. And if we could go back to CLC Exhibit 49, pardon me. Do you see the scale? Could you go down another page? One up and down, these two, 4 and 5. Do you see that the scale, at least between December 2022 and February 2023, the numbers were quite high? And if you go back to your own exhibit, which stops at 2022, that 10,400,000 in December 22 is one of the ones that was identified as an outlier, right?
Yes.
So do you have an opinion as to whether, if you had incorporated 2023 and 2024 data, whether you would have found more outliers?
I could definitely speculate. So, I mean, if I would have expanded it, these numbers would have changed the average, the standard deviation. So they very well might have, but also the expanded data would have changed the confines of the test, basically. So it's not a guarantee.
Okay. The hearing examiner was asking you about the WEAM reporting, and you said that about the WEAM numbers and the benefits, and you said that you'd gone to the WEAM website and found a quarterly benefit test. Do you know how the WEAM measures benefit for that test?
I believe in that the report. I mean, I did kind of look at this kind of as the 23-00222/UT case was going on, because it also had to deal with the Western energy imbalance market. But I believe it was in dollars, but as far as how they calculate the benefits, I do not know.
And working backward to another analysis, which was in the discovery response, I think the information. Yeah, DAC3. Could you go back to that one? And what you were working on with the hearing examiner was a hypothetical example of the two methodologies, right? Your own hypothetical?
Yes. Yes.
And earlier in the day, you testified that you did go back and look not only at the recommended decision in case 20-00104-UT, but you also looked at Mr. Hernandez's testimony, or was it just his exhibit AH5?
I probably searched his testimony and then went to that exhibit. So
okay. So do you think that based on what you saw in that record, that the commission, and including the hearing examiner, that the commission considered, was aware of these two options for what EPE's proposal was and considered them? Let me break it down. Do you think the commission was aware of the possibility of alternative means of construing what a rolling average was?
I mean, like I said, I didn't read the case in depth, and I had a look at the exhibit. That being said, when I did that, I didn't see, any examples or contrary examples of how the average could be calculated. No.
You say you didn't see any contrary examples. Did you see something that demonstrates that should be calculated the way EPE does. And I guess I would ask you to refer to Ms. Reza's rebuttal testimony. She has an exhibit that is AH5. Let's see, Reza's rebuttal. I think that's EPE exhibit 4. Right, Reza. There's going to be a lot of exhibits here. Yeah. And
What page?
I think it's her JIR1R. So it's
What page?
let's go to, I think she testified the other day, but starting at page 9 of 14. So I'll ask Mr.
Well, you've already got a pending question.
Okay, yeah.
Answer if you know, Mr. Molden.
I'm sorry, can you repeat the question, please?
I wasn't sure I completed the question, but do you see anything in this exhibit which which she incorporated? Which you understand? This is exhibit
Just
A.
ask the question.
Do you see
Do you
anything in
see
this
anything?
Do you see anything in this exhibit that tells you that the commission, that the mechanism would be developed by adding the rolling average of the price, as Mr. Streidel called it, or the monthly cost per kilowatt hour, and averaging that methodology? What do you see here, or what do you see here that confirms that that was what EPE proposed?
I never said that it was confirmed that that's what they proposed. And I don't see, and I didn't see a table like in the 550 reports that shows how they calculate it in this. That's not to say it's not there, because I can't confirm that. But yeah, so I mean, really, I mean, all I see is the 12 months factors here.
You
in
see
this
the
exhibit.
end factors, or do you see this idea of how those end factors are calculated?
I see the factors.
Okay. I think I'm working backwards here. And I think that, oh, yeah, okay. When the hearing examiner asked you about that on page 12 of your testimony, you stated that EP is not requesting to reconcile its fuel clause. And then she asked, should they? Your testimony was, I would never be opposed to that. Can you tell me what, well, first of all, let me tell, does that mean that you are supporting reconciliation for any period in this case? With staff, you as a representative staff are supporting an order approving reconciliation in this case?
Given that it wasn't proposed, and I didn't say that in my testimony, I just say that I think it's generally a good idea to do it. But as far as me proposing it in this case, no.
And you haven't done an analysis that would make you comfortable supporting that conclusion, have you?
As far as no, just in principle, I think, it's good practice to match the cost to revenues. Or
But you didn't confirm that they matched the cost to the revenues.
I don't. No, I didn't.
This is the last one, I promise, the really last one. At the very start of her examination, you were talking about the CLC2- staff's response to CLC2-4, and you concluded with something to the effect that it's also worth noting these scenarios are very unlikely. There was no time when net purchase power is negative, as in December 2022. Were you listening to Mr. Provencio's testimony yesterday? Yeah.
Yes, I was.
And do you recall that on redirect, he corrected himself and said that it was the month of February 2023 in which the signs flipped?
Yes, but I think you're misunderstanding that I wasn't talking about the balances being flipped. I was talking about the net purchase power
Okay.
actually being a credit.
Okay, good. And then in the same answer, you said that, you know, the other reason why it was their scenario was very unlikely was that you there were no other billing errors over the 6-year period. And I wanted to just ask you, what did you do to verify that there have been no other billing errors over the 6 years?
Well, I looked at the spreadsheets and calculations, which granted, I mean, if it's a billing error, it may not show up, but in this case, EP was transparent. They reached out to staff council. They let us know. They included it in the 550 report. So I have no reason to believe that they wouldn't have done that in the past, as well as my analysis of the 550 reports in Excel format.
And did you go through I hope not, did you go through 6 years of cover letters to see whether they had disclosed any billing problems?
No, I did not go through 6 years of cover letters.
Gotcha. Okay, thank you very much, Mr. Malden.
Thank you, Ms. Stevens. Ms. Souls, anything further?
Yes, please.
Go ahead.
Mr. Malden, do you recall when the hearing examiner was asking you about the other witnesses' various testimonies and this question of price versus cost? Do you recall that?
Yes, ma'am, I do.
And was your response related specifically to WEIM?
No, I think it was just conceptually the differences in my head of cost versus price.
So your response was related to power market transactions?
It was more so related to the definition of those words, because that's what shows up in the rate case, which changed the base factor, is the word cost. And basically I drew a hypothetical kind of situation to say that in this instance, I think the cost and the price are the same, referring to the same thing.
Could we look at a 550 work paper A, please?
Do you have an exhibit number you want to refer me to? Does it make any difference?
Ms. Riza's testimony, which would be El Paso Electric Exhibit 3, included the 550 work paper A. I believe in El Paso Electric Exhibit 3, Ms. Riza's direct testimony, her exhibit JIR-2, and we had previously looked at page 342 of 390. And the PDF numbering, that would be page 369 of 419.
Okay, I'm there.
So if you recall, maybe you're familiar with this work paper A format. Are you?
Yes.
And you see the section interchange out that starts with line 20. And do you recall what line 20 represents according to Ms. Risa?
Represents sales or revenue. I believe.
If I portrayed to you that she said the revenue was the combination of line 20 and line 24, do you recall that?
Yes, I would. Yes.
And do you understand, Mr. Malden, that revenue generally is related to price?
Sure, but at the same time, price is also related to, in general, a markup for a product.
Do you recall, Ms. Reese? Go ahead.
In this case, there is no markup. So, I mean, they're flowing through costs.
What
Just
do you
because a
understand
customer pays for it doesn't make it a price.
What do you understand line 24 to represent?
That is the margin that EPE makes off of selling electricity or, anything from interchange out, they make a margin on it, and that's shared with the customers at 100%.
And do you understand margin to mean the same thing as markup?
Yeah, they don't mark up the cost of electricity for customers.
Is it your understanding that line 20 plus line 24 is what Ms. Risa represented as resulting in the revenue from sales?
Sure, but she's not referring to sales to customers. She's referring to like arbitrage sales on a market that EPE makes money, which benefits customers.
You recall her testimony, or maybe it was Mr. Martinez's testimony, that this line is arbitrage sales and power market transactions sales?
Which line are you referring to, Ms. Souls?
Line 20 and line 24 that result in the revenue that's not independently represented here?
And we're looking at work paper A,
Yes, ma'am.
because I have line 24 is labeled SRSG. Are you sure you're not looking at 27?
Let's go back. We are on exhibit JIR-2, page 342 of 390.
Okay. And 342 is the number at the top.
In her exhibit numbering, yes, ma'am.
Okay.
Work paper A, page 1 of 4, month of March 2022. I have line 20, says firm.
Okay.
And I believe Mr. Malden indicated he understood Ms. Risa to say that was the cost of sales.
And line 24 is entitled 100% margin sharing.
Yes, ma'am.
Okay, go ahead.
So Mr. Malden, would you agree that revenue is typically the price times the volume of a sales transaction?
Can you rephrase that? Or actually, can you just ask it again?
Revenue would be the price times the volume of a sales transaction.
Sure, yeah.
And would you agree then that based on what you just confirmed regarding Ms. Risa's explanation, that this has line 20 plus line 24 would be the revenue from sales transactions. Would you agree with that?
Line 24?
Line 20 plus line 24.
Yes, yes.
So then would you agree that if line 20 is the cost, that it cannot possibly be the same as the price in all circumstances for this accounting? Would you agree with that?
I think you're kind of mischaracterizing my point. The
Please
cost
help
that
me
EPE
understand.
incurs to furnish customers with power is the only thing passed through the fuel class. That's my point. Like, and dividing the cost by the consumption for every month doesn't make the cost per kilowatt hour a price. That's the gist of my point. It basically just normalizes the cost by the consumption for every month. So you get a cost per unit for every month.
Cost per unit of what, Mr. Mullen?
Dollars per kilowatt hour.
Are you referring to the factor that is then charged to El Paso Electric customers?
I'm referring to the base fuel factor, not the factor that is charged on bills.
Then am I to understand that when you responded to the hearing examiner's question regarding price versus cost, you weren't responding regarding sales transactions that El Paso Electric engages in? Is that
I
correct?
was solely referring to the calculation of the 12-month average.
Thank you, Mr. Malden. I appreciate that clarification.
No problem.
Anything further, Ms. Holes?
No, ma'am.
Thank you. Thank you, Mr. Walden. You're excused,
ma'am.
sir.
Thank you.
Anything further from staff, Mr. Black?
There I am. No, nothing further from staff. Thank you.
Very well. I believe that this concludes the evidentiary portion of our case. Therefore, I think we need to discuss any post-hearing writings. I'll issue a specific briefing order, but the issues that I think are appropriate to include in any post-hearing brief. I'd like to see some case site reference for commission authority and practice on prudency review. I'd also like to see some reference or precedent for a public utility not having an Fppcac. And then the third issue has to do with what precedent or reference does the commission have regarding reconciliation of Fppcacs? Anyone want to offer a time frame for a briefing and response, or should I just say 2 weeks from the final filing of the transcript,
Madam
and
Hearing
then
Examiner,
Ms. Souls.
I would like to make a specific request, and that is that it not be prior to August 2nd. I have about 3 weeks worth of unavailability in the month of July.
Madam Hearing Examiner, I think that's, we could ask Mr. Lee, but I think that, you know, there's a holiday in there. So I think that the way when would we see the transcripts, Mr. Lee? I don't
I
think it's-
believe, Ms. Stevens, that the agreement is that it's 10 business days from
Okay.
when the date is. Is that correct, Mr. Lee?
Yes, ma'am.
So
July 15th because of Monday, July.
Miss Stevens, you are
Yep.
breaking out. Are your notes on your computer again?
I got my calendar on the computer again. You know my problems, Mr. Lee. Thank you.
so
Start again.
So yeah, I mean, we can say that the transcript hopefully will be in by the 12th. So that basically would be 3 weeks. So you said August 12th would be okay for you?
Ma'am, August 12th would be okay, but for clarity, I said no earlier than August 2nd.
I'm sorry, I meant August 2nd.
I'd be happy with the extra time, but that's okay.
Yeah, let's make it August 5th then.
You don't want to spend the weekend reading briefs, Madam Hearing Examiner?
Madam Hearing Examiner,
You don't
I
like that?
no. Mr. Wexler and I are both in addition to the fuel clause hearing, which is scheduled that week, we have a substantial rulemaking that week, so, if
Better
we
get
could-
Miss Harris in there.
Yeah.
Got
If we could-
any more associates?
We're pretty thin right now. If we could push it to the following week, that'd be really helpful, but, I understand if you want to get it sooner.
Well, it's Epe'S case. I'm just trying to, you know, I'm just trying to get it going, especially after the reference about somebody made about case lagging, which I didn't appreciate because you know what? The parties asked to have for the case to be held in abeyance. Wasn't me.
I think talking about lagging, I think the only one the company has a complaint about is the cold weather case. I don't think you heard lagging from us.
I didn't. It wasn't you. So let's just say then that. So then you want the 12th.
She wants the 12th.
Yeah, the 12th or even the 14th.
Well, I'll be in hearings with SPS, so you can have the 12th or the 14th, Miss Olson.
All right, I would pick the 14th if the other parties are amenable to that.
Okay. All right, and then we'll say the 16th. We'll say the 23rd for any response briefs. Please make sure that you comport with what rules are left about page limits, etc. Because I forgot to ask Mr. Malden. I want to know what font he used in his testimony. I mean, I know my eyes are not the best, but it sure doesn't look like a 12 to me. But be that as it may, yeah, just you know, be as brief as possible. You know, if you want to submit proposed findings and conclusions, you know, try to make those joint mean, I realize that some of the positions are pretty disparate here, but you know, it would be nice if you all could agree on what time of day it was, but okay. I'll issue an order with the three areas that, you know, I want to see some party direction on. And then we'll have initial post-hearing writings on August 14th. We'll have any responses August 23rd. Okay, the other matter.
Madam Hearings, before you move on, can I ask one thing?
Yes,
that you
ma'am.
could clarify in that order, when you're asking for authority or precedent references, I taking it that you're talking about PRC authority, or do you want
Yes,
us to
ma'am.
go outside? Good.
Well, yeah, I mean, obviously, if there's not, if someone wants to say 43 of 50 commissions, you know, do it this way. You know, I mean, if you think you have some authoritative
Yeah.
that would be duplicative, wouldn't it? Authoritative authority. You know, I mean, if you think you have something helpful, you know, not some obscure, you know, whatever, but some prevailing thought. I mean,
No,
from
that's entirely how I interpreted what you were thinking. I just wanted to make sure that we
okay,
were.
what was I doing?
Point to.
Oh, all right. So basically, then just the other thing, and this may be a more appropriate discussion for Mr. Lee and myself to have. But is there any objection from the parties that the confidential exhibits as admitted be delivered to, or that the confidential exhibit content stay as provided to the commission, and that the notation in the transcript is just going to be the pink paper exhibit placeholder? Does anybody have any objection to that?
Madam Hearing Examiner, will it be clear how someone can access those parts of the record?
Can we put a note in there, Mr. Lee, that says that the content of the confidential exhibits can be accessed through the commission's records department to those who have signed the confidentiality agreement, and make arrangements with the records division to view that information at the commission offices?
Yes, Judge.
Very well.
Madam Hearing Examiner,
Ms. Souls?
I'll just do this again, but I think we need to do the same thing for the voluminous.
Yeah, but I'd
other-
only wanted to do one at a time.
Oh,
So that's why I
okay,
chose the confidential ones first. Okay?
got it.
So
And then just
they're staying
be-
here in just the reference. Okay?
Mhm.
Are we all good with that? Okay. Then the second thing is, and I was trying to check that, and I actually popped down to IT, and I'm gonna talk with Ms. Sandoval, because, and again, you know, not as an excuse, but as an explanation, the transportation division is being moved as of Monday. And we've already gotten emails saying the InfoShare may be intermittently down today and Monday for the separation. Okay, you know, they're saying it might not be, but be prepared. Okay, so I can't actually probably get to speak with Miss Sandoval, but I can tell you from just going to InfoShare that it's not clear to me that the voluminous, that it, actually it is. I was able to download Ms. Soul's testimony from InfoShare.
Really?
Oh. And it is 92.9 megabytes. So I think I'm going to be able to just put it on a flash drive and provide it to Mr. Lee. Does anybody have? I'll make sure that it includes all of the exhibits. That so even though it's not confidential, my thought is that when it comes back as part of the transcript, that that Ms. Sandoval will be able to have it in the InfoShare. Okay.
Madam Jury Examiner, I'm really confused. Are you saying when you were able to access it from InfoShare, you were able to open all those pages of like the MLS4? Or are you just talking about?
That's not what I said.
Not you're
That's not what
separating
I
the
said.
exhibits. You're separating the exhibits from the testimony. Is that what
I'm saying? I was able to download all of MLS1, and it's 92.9 megabytes. And that I would check to see how many of the exhibits were included, and if they weren't, I would put her attachments with it to put on the flash drive that will go to Mr. Lee, so he has the exhibits, and then come back. I mean, does somebody else see a better way of doing that? Nobody's saying anything. Yeah. Okay. And there's no objection to this. So, Ms. Olson, does that answer your question?
Yeah, I think so. And so I guess when you open the transcript and then you open up, or you get to the end of the transcript that says MLS1, it will just have those same placeholder PDFs, and there'll be some notation of where to access those exhibits.
Yes. And, you know, unless somebody, and let me just say, this is provisional to me being able to talk with the head of records and the head of IT, neither of whom is available to me right now. But, you know, I sort of haven't been in this position before where, you know, I've had such voluminous documents that they just can't be downloaded in the court reporter, take them from the Dropbox. But again, none of us wants to see thousands of pages of documents, do we, attached to this testimony? I mean, to this transcript. You know?
I'm even more confused at the moment now when you're saying MLS1. You're not. You are talking about Souls one, her.
Yes. Yes.
Text and all the public exhibits.
I told you, Miss Stevens, I don't know yet. I have, you know,
okay.
I downloaded it in the 1 minute break I had earlier. So I can't tell you what's in it. I just know that I was able to download 92.9 megabytes.
Yeah.
So, all right, I'm not hearing any objection to the procedure that I want to utilize. So I'm just going to go with it, subject to my conversation. Mr. Lee, are you okay with this?
Yes, Your Honor.
Very well.
I do have a further question, and this is down the line though. In terms of if a record proper for an appeal were needed, would we go in and unravel all this as necessary to also get stuff to the court? Because Melanie and I worked on it.
That's why I have to talk with Miss Sandoval to make sure that I am including in the records the appropriate thing. And as I've said 4 times, I can't get to the keeper of the records or the head of IT right now. Okay, sorry, I'm not a priority.
No, I know. The court told us 250 pages of PDF per volume. That's why I'm raising this, because God only knows what would happen, you know?
Yeah, well, I mean, obviously, one would like to think there's not going to be an appeal on this, but you know, that doesn't, you know, given the composition of the parties in this case, I don't know that that's going to be possible, but you know, the commission will do its best to make a decision that's legally and factually appropriate. If we don't have anything else, thank you very much for your participation in the case, and we are adjourned.
Madam Hearing Examiner, we're off the record.
Yes,
Are you going to pick up your dog this afternoon, or is she still?
Don't know. Don't know.
Oh,
Haven't
she could go
had
home
any
through the
personal
weekend.
phone calls, but thank you. I appreciate that, Ms. Stevens, and hope everybody has a nice weekend.
You too.
Thank you for all of your hard work here. I can't tell you how much I appreciate it.
Appreciate that, Ms. Souls. Thank you.